Yay. All persons having visited before the Honorable Beverly Kenobi, Justice of the Gulf Coast Superior Court, before they come to your Gulf Court. Give your attendance, you may be seated.
Your Honor, this is 22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Adam Lally for the Commonwealth. Good morning.
Good morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Your Honor, Alan Jackson on behalf of Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Attorney David Yannetti on behalf of Karen Reed.
Good morning, Mr. Yannetti.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little. Good morning, Ms. Reed. All right.
Could I just have, Mr. Reddington, could you identify yourself for the record?
Sure. Kevin Reddington, I represent Jennifer McCabe.
Good morning, Mr. Reddington. I appreciate you joining us today. I know that you're out of the country. Thank you. All right.
Hey, Kakyu, can you hear me? Thank you for joining me. I just want to see if my mic and everything's working. I'm glad you're here. Oh, thank you. Okay, so I wanted to go through all of the pretrial motions, but I'm having trouble finding them all in one place like I thought I could. I have the entire first trial minus all the fluff, like all the sidebars and stops and starts are taken out lovely by the trial channel. So I have the entire first trial. I just don't have the pretrial motions. I thought they had a separate file for that, but they don't. So I found this one, which I was interested in. So I want to go through this one, and then if I can get someone else is helping me look for pretrial motions, all of them for the first trial in one spot. So if I can get that, we'll go through those. Otherwise, after this motion, I'm going to start opening statements, and then we'll come back to some pretrial motions once I find them. But my point in doing this is I have been working on some video, a couple videos, but one in particular about group thinking in the Karen Reed movement, especially on the anti-Karen Reed side, who sometimes, well, not sometimes, most of the people in the anti-Karen Reed movement seem to rationalize, evidence that they can't explain. And then they also, I'm trying to put this in a nice way, they literally can't grasp common sense. And they get within this group of people who all believe things that defy common sense and defy what their own eyes are telling them. And I think to fully grasp this, in this group in particular, I need to watch the first trial. I have not seen the entire first trial. I've seen clips, obviously, on YouTube, but I think watching the entire trial will give me a little better perspective of how, they think that way. So thank you. I know, because with you and your true crime, and especially with Dr. Mona being in psychology, I had a feeling you'd probably think that way as well. So it's good to know that obviously I'm not the only one, thinking that. And it's something that boggled my mind for quite some time. Yeah, and you, if you go and check, I know you're kind of new to the Turtle Boy world, especially. If you look at one of my shorts I made, it says "Oh Plebin" at the top, and he's a guy who wrote a book after the first trial, who at first believed that his name is Kevin Lenahan. I don't know if you watched Samantha Beningo, who's also a psychologist who's getting her doctorate and her PhD. But she does awesome breakdowns, everything in the Karen Reed trial. And she had him on her show because she's level-headed. She can have a conversation with someone who disagrees with her without resorting to name calling and stooping to that kind of level. But she had him on, and this guy, Kevin Lenahan, first he believed Karen Reed was innocent. And then apparently after the first trial, and I'm not sure, I don't really watch his stuff, I don't know the entire history there, but I do know he switched sides and now believes that Karen Reed is guilty. He made, I watched him, he was on Samantha Domingo's show, this is the I Don't Belong Here show, talking to her, and every question that she asked him, like for specifics, like, and he literally said, she is indisputably guilty. Like, it's indisputable evidence. And yet, every single question she asked him about specifics. Well, how is it that this happened? And I mean, for example, how do you get hit by a car and not have a bruise or a broken bone? And his answer is always, I don't know. I don't know the specifics. Well, you can't sit here and answer every question, I don't know, and say it's indisputable evidence. It just doesn't work that way. But there are a lot of people that feel like he does for some reason, and I don't get it. And I have always been one of those people that wants to understand things, and I want to understand how people come to those kind of conclusions. So, all right, I appreciate you being here, and we're going to start with this motion. And while this motion is playing, if I can find more motions, the pretrial motions, I will do those after this one. If not, I'm not even sure how long this one is, but if not, we'll go to opening statements. See what? Okay. So based on the injuries alone, I believe she's innocent. Yes, I have a medical background, and I have believed since day one. Okay. Well, that's good to know, because I know when you were, in my chat the other night about, how I met you in the Drunk Turkeys chat, Drunk Turkey Show chat, and I wasn't sure of your opinion on that until the other night when you said that you felt she was innocent as well. And I didn't know how long you felt that way. And I can, for anyone who, watches this at a later time, I, for one, can tell you, I didn't watch the first trial. I only heard snippets here and there from watching The Lawyer You Know. And it wasn't until the Lawyer You Know had mentioned Turtle Boy several times in his streams where I was like, okay, I need to go figure out who Turtle Boy is. And once I did that, of course, I went down the Karen Reed rabbit hole and found the Karen Reed movement and anti-Karen Reed movement. And it wasn't until I even started watching the second trial that I even made an opinion. I didn't know, because I knew right away I didn't know really any of the evidence. I wasn't really paying attention to it until I did some research. And just doing a little bit of research and then keeping an open mind when the second trial started, all I could think of, every day I watched that second trial, I'm like, is this a joke? Like, and I can't even go into the Blue Man group, the Blue Paint Test Boys who thought that proved something. I that was beyond my comprehension. I'm telling you. Let's see, what do you say? I am always terrified to give my opinion on Drunk Turkey. Up, his mods have ripped me to pieces several times. It's funny because I've never, before getting into the Karen Reed movement, I was never a big chatter. I would lurk. I have been watching YouTube for years, and it wasn't until basically around the second trial that I started actually chatting in other, in streamers chats and things like that. And I found the Drunk Turkey Show last year when I was looking for some, Koberger stuff, some news on it. And I liked the way that he was reporting the information. And I liked the fact that he was former law enforcement. And I appreciated his show. And I chatted very little, you know me. I that's how I met you. I wasn't in there a lot. But I did. I commented here and there, and especially, the missing children in Canada. I was watching him for that. But I didn't agree with his take on it much. And anytime I said something remotely different or that disagreed with him, it wasn't him. This isn't him. I don't think he has any issues with people who disagree with him. But it's definitely his chat and his mods. They will rip you to pieces. I mean, I think I told you the story the other night. I don't know if you were on when I told this story, but by the time I made this comment, I had fully believed that, Karen Reed was innocent. She had been found innocent. And he made a statement on one of his shows that he believed that Karen Reed had gotten away with murder. And I was shocked by that, truly shocked that he believed that. And so I wrote in his chat, I said, did you watch both trials? One question mark. So it wasn't like I was putting emphasis on anything, nothing. It was a simple question, just said, did you watch both trials? And he said, yes, I did. That's all he said. And he may have made one other comment, but it wasn't bad or derogatory or something. But as soon as I did that, as soon as I made that question, his chat went off on me. I didn't even say anything besides asking him if he watched both trials. And to be honest, I don't think anyone who truly spouts off about her being guilty has watched the entire both trials. I don't know how you can watch, especially trial 2. I don't know about trial 1. That's why I'm watching it now. I don't know how anyone watching trial 2 can think that she is guilty of this crime. It boggles my mind. So yeah, so you get it. You get, and that's the thing. That's why I started this show. I started my channel, my show, because I have an opinion. I made a joke in my last live how I was voted most opinionated in high school. Well, might as well put it to some use, right? So, but I'm not doing it, I don't want to create a drama channel. Of course, I like to have fun and share a little laughs, especially with things that don't make sense to me. But overall, I want to explore things, and with me exploring things, if that spreads or helps someone else explore things or see things differently, or even helps me see things differently, hey, that's all I want from this. So I appreciate you being here. And so you get it. So like I said, you get it, what I experienced on his chat. And ever since that, I won't even go watch his show live anymore, because I will feel tempted to make a comment, and I don't want to get attacked like that ever again. It's the only time I've ever truly been attacked or anything in someone's chat. And I didn't even do anything. I didn't even say anything. I asked him one simple question, and that's it. So pretty crazy. So I don't blame you if that's what, if you if you avoid that too. All right, so let's watch this one, and then we'll see where we go from here. I'm going to be totally honest with you. I don't even know 100% what this motion is for. I know it is regarding some type of evidence that is trying to get in. So let's see where this takes us.
So we have 4 sets of motions. The first one that I would like to address.
Free my boy Tidsy.
What was that, Jim?
I don't know what that was.
I think it was somebody on Zoom.
Nobody can speak, so it only could have been maybe. I think we're all set.
All right. So the first motion I'd like to deal with is the defendant's motion for Rule 17 records directed to Jennifer McCabe, Trooper Michael Proctor, and Elizabeth Proctor. Who's arguing that for the defense? All right, I'll hear you, Mr. Jackson.
Free my boy Billy Tibbetts. Free Billy in the trap.
Kevin, could you just be either mute or watch us?
Jim, that's not me. It's somebody else is saying free my boy Billy Tibbetts. That's not me.
Okay. Thanks, Mr. Reddington.
Thanks.
Go ahead, Mr. Jackson.
Kevin, that was you. Good morning, Your Honor, and thank you for giving us the time to address the court on these summonses for the third-party communications. I think I can cut this relatively short, given the Commonwealth's position that they are in agreement that the summonses for these third-party communications should issue. I want to save some court time.
Billy's innocent.
All right, so we may have to cancel Zoom for everybody if this keeps up. We will have to cancel Zoom for everybody if this keeps up.
I think
You gotta love when people snipe a Zoom hearing in the court. That is too funny.
got that person, but
Fuck off, Beverly.
Maybe I didn't.
Go ahead, Mr. Jackson.
Thank you, Your Honor. I want to try to save some court time and judicial resources. If the court is inclined, given the Commonwealth's position, that they are in agreement with us to issue the summonses, I'll just submit on the papers.
Oh my God, did that guy just say fuck off, Beverly? I'm sorry, but I have to rewind that.
The time to address the court on these summonses for the third-party communications. I think I can cut this relatively short, given the Commonwealth.
Hold on. Oh, maybe around too far. Hold on.
Good
That
morning,
has,
Mr. Lally.
if that guy, whoever sniped this Zoom hearing, said what I think he said, oh my God. Perfect way to start something that was way even before the first trial for someone to tell her. I'm sorry. Wow.
Good morning, Your Honor. Laura McLaughlin for the company.
Good morning, Ms. McLaughlin.
Your Honor, Alan Jackson on behalf of Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Attorney David Yannetti on behalf of Karen Reed.
Good morning, Mr. Yannetti.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little. Good morning, Ms. Reed. All right.
Could I just have, Mr. Reddington, could you identify yourself for the record?
Sure. Kevin Reddington, I represent Jennifer McCabe.
Good morning, Mr. Reddington. I appreciate you joining us today. I know that you're out of the country. Thank you. All right. So we have 4 sets of motions. The first one that I would like to address.
Free my boy Tipsy.
What was that, Jim?
I don't know what that was.
I think it was somebody on Zoom.
Nobody can speak, so it only could have been maybe, I think we're all set.
All right. So the first motion I'd like to deal with is the defendant's motion for Rule 17 records directed to Jennifer McCabe, Trooper Michael Proctor, and Elizabeth Proctor. Who's arguing that for the defense? All right, I'll hear you, Mr. Jackson.
All right,
Free
let's
my
hear
boy
this.
Billy Tibbetts. Free Billy in the trap.
Kevin, could you just be either mute or watch us?
Free Billy in the trap. Okay, so I got that.
Jim, that's not me. It's somebody else is saying free my boy Billy Tibbetts. That's not me.
Okay, thanks, Mr. Reddington.
Thanks.
Go ahead, Mr. Jackson.
Kevin, that was you.
Good morning, Your Honor, and thank you for giving us the time to address the court on these summonses for the third-party communications. I think I can cut this relatively short, given the Commonwealth's position that they are in agreement that the summonses for these third-party communications should issue. I want to save some court time.
Billy's innocent.
All right, so we may have to cancel Zoom for everybody if this keeps up. We will have to cancel Zoom for everybody if this keeps up.
I think I got that person, but.
Fuck off, Beverly.
Oh, he so did. Fuck off, Beverly. Whoever that was, so called her shit way before Karen Reed's trial. Oh my God. I can't believe that. I can't believe I've never heard that before. And all the stuff that I have seen and watched and people make fun of and all, oh my God, all the parody that is going around with this trial and her and Lally and Brennan, it cracks me up that I never heard that before. Oh man. I wonder if anyone ever found out who that was. I'll have to go looking. Yes, I should. I think I'm going to do that after I get done with the stream today. It's, oh my God. Because I literally search for the parody stuff because it just makes me laugh. And in the community that I am, and Rat House Media, especially the friends that I've made from there and the Discord there, I mean, they make so much stuff. It's so funny. And I have never seen that. That's one thing I haven't seen anywhere. It's going to be fun. I hope I get more stuff like that watching this. Make it a little less boring. All right, let's see.
Go ahead, Mr. Jackson.
Thank you, Your Honor. I want to try to save some court time and judicial resources. If the court is inclined, given the Commonwealth's position that they are in agreement with us to issue the summonses, I'll just submit on the papers and be done.
I have third parties that need to be heard.
If the court wishes, I'm happy to address the third party concerns once they are heard.
No, I'll hear you now.
In terms of the papers that were filed, and my understanding is Mr. Reddington joined on Ms. McCabe's behalf with Elizabeth Proctor's motion and her position filed by her counsel. It basically comes down to a singular issue, and that is one of privacy. They don't have standing to argue Lampron. They're not parties to this action. It appears the Commonwealth, who is the party to the action, has agreed that Lampron, the elements of Lampron have been met with our request insofar as it is concerned, specifically an address to Michael Proctor, Trooper Michael Proctor, and his communications with Jennifer McCabe, Elizabeth Proctor's communications with Jennifer McCabe, Jennifer McCabe's counter communications with Elizabeth Proctor, and Michael Proctor's communications with Brian Albert and Nicole Albert. I'll address the issues that counsel raised in his moving papers on behalf of Elizabeth Proctor, because that's the only writing that I have to go on at this point. He basically argued that there are false statements made about Michael Proctor's relationship with some of these other parties. Since the very beginning, and that brings up the fundamental issue, Your Honor, of what is that relationship and what's the nature of the relationship, and why do we believe that relationship establishes extrinsic evidence of bias and an inability to be neutral. From the very beginning of this case, we have questioned the neutrality and the bias of Michael Proctor and certain other government witnesses based on overwhelming facts that we've learned, overwhelming facts that establish that both this investigator and this investigation are compromised. That's why we...
Do you have that, Tori?
I cannot believe that somehow they got back in. I never saw any of this. I did not know that not only it happened once, it happened more than once. Wow. What a way to start.
Okay. Go ahead.
Thank you. That's why we've asked for the communication.
Poor Alan Jackson, man. There's nothing worse than them, making an argument and having to constantly get interrupted. But damn, that's funny.
That the Commonwealth has now agreed with. Our request is nothing short of critical to our defense, obviously, and it's based on Ms. Reed's constitutional right, as established in Davis versus Alaska, the U.S. Supreme Court constitutional right, that's recognized as the right to attack the credibility of any government witness, be they a government witness on behalf of the police and the investigation or any other government witness.
Is Elizabeth Proctor a government witness?
She is not, but Jennifer McCabe is. And the communications that we're interested in are the communications that are concomitant between Elizabeth Proctor and Jennifer McCabe. We've established that there is a close personal relationship between and among Michael Proctor and obviously Elizabeth Proctor and these third-party culprits that have been implicated in this case that we've brought to the court's attention, the Alberts and the McCabes. That's the relationship, and that's the foundation of our request. This is so important that I'll bring it back to the court's attention, and the court knows this, that even the sitting DA, the elected DA, decided to weigh in on this issue of the relationship between the Proctors and the McCabes and or the Alberts. And he said there's no such relationship, zero. This doesn't exist. As a matter of fact, the word that he used was, it's a lie. Any suggestion to the contrary that there's any kind of relationship between the Proctors and the McCabes or the Proctors and the Alberts is a lie. His words. So the DA himself has put Trooper Proctor's neutrality at issue, and he did it in the most public way possible, and I would suggest a clumsy way. Who was he talking to? He didn't come into this courthouse and address the court, as we've all done. He didn't address the court. He didn't address the Commonwealth. He is the Commonwealth. He didn't address us, the defense. What he did do is he addressed the public and the potential jurors. And that was by design. So he calls the evidence that we've procured and that we've presented to the court as lies. Well, let's look at those lies for a quick second. We have presented the court with photographic evidence, not something that we came up with, something they came up with. Photographs in Exhibit C in our moving papers. And I'll just cover a couple of those. There's a photograph that we presented that shows Trooper Proctor's mother, the person by the name of Colin Albert, pictured in the photograph, with Trooper Proctor's sister pictured in the photograph, with Chris Albert pictured in the photograph, and with Jennifer McCabe's own daughter depicted in the photograph. They're all together at a birthday party. These are close and immediate family members of the Proctor family, the Albert family, and the McCabe family, and they're all together and they're socializing. That's not a lie, it's a photograph. And it's unassailable evidence of that relationship. There's a second photograph of Trooper Proctor and Colin Albert in a wedding party together. And I would urge the court to note, they're not at a wedding together, they're in a wedding together, in the wedding party. There's a third photograph.
And
Trooper
when was
Proctor-
that? When was
sorry?
that? When was that?
2012. So this relationship, as the court just noted, and I was about to get to in a second, is not just days old, months old, weeks old. This relationship is decades old between these families. There's another photograph that the court has seen, Trooper Proctor literally on the dance floor with Colin Albert. So when counsel for Elizabeth Proctor suggests, oh no, these relationships, you can't believe any of this stuff, just because someone happens to be at the same event does not thereby establish a relationship. They weren't just at the same event. They're in a wedding party together. They're standing on the dance floor, side by side, shoulder to shoulder, Trooper Proctor and Colin Albert. And then we see a photograph of all of them seated at the same dining room table. They shared a meal together. This is socializing. These are interpersonal relationships, and they can't change that. Trooper Proctor was seated at the same table, having dinner.
I do have to say that one of the biggest things, especially from what I've seen in clips of testimony in trial 1 and in trial and what happened in trial 2, is how much all of them want to distance themselves from each other after the fact. Like all this history that was a little bit of it that Auntie Bev let in this trial. There was so much I know that I've heard and some that I've seen wasn't allowed in. And that's where I'm interested in digging. And I know I think her whole case file finally got released, and I'm trying to get my hands on that. So, but as far as personal relationships between this whole group, it's insane how all of them crawl back to, oh no, it's not as close as you're portraying it to be. Oh, fuck off. Yeah, it is. And if they're not guilty of something, what does it matter how close they are? Why are they all so insistent that their relationships aren't as close as, the defense portrays it to be? It doesn't make any sense.
With Colin Albert, Chris Albert, and Chris Albert's wife, Julie. Then there's the Facebook post, and I will leave it at this. I'm not going to go through the entirety of my motion, but I would highlight the last point that I think should be highlighted for the court's attention, and that's the Facebook post. Trooper Proctor's mother refers to the Albert family as the Proctor's second family. So one might actually ask, Mr. Morrissey, who's actually lying in this case? Is it us? We just presented the court with factual information that was procured off of social media that it's unassailable. It cannot be assailed. And the Proctors have known these people for, as the court just mentioned, by asking for that date, for more than a decade. They've socialized with him, and his family considers their family to be so close and interconnected that they are deemed a second family to the Proctors. And who exactly?
Yeah, exactly. Yeah, you can't do it. I mean, because anyone you consider an extension of your own, blood related family. And even if you didn't see them that way and refer to them that way, you still, even if you're just a friend or good friend, you have a history that is captured, and especially in this day and age where everything is photographed, video recorded. I don't, they made themselves look guilty. I mean, I'm sorry. They made themselves look guilty from the very beginning when they were doing a timeline at the table the next day. These are cops' wives, okay? Their family members are cops, their husbands are cops, some of them are cops, and they're all in a room together knowing that they are, whether they are witnesses or suspects or persons of interest, it doesn't matter. They know better. All of them knew better. They knew they shouldn't be sitting in the same room discussing a timeline. It's insanity to me.
Are members of this Albert family and or McCabe family. Let's look at those members. Brian Albert, Nicole Albert, who is Jennifer McCabe's sister, Brian Albert Jr., Brian and Nicole's son, Caitlin Albert, Brian and Nicole's daughter, Jennifer McCabe, Nicole Albert's sister, Matt McCabe, Brian Albert's brother-in-law, Chris Albert, Brian Albert's brother, Julie Albert, Brian Albert's sister-in-law, and Colin Albert, Chris and Julie Albert's son. The McCabes and Alberts ostensibly are one family. They socialize within the same social circle and the same familial circle, and that is who the Proctors have proclaimed to be their second family. And if that weren't enough, we find out during the pendency of this case on September 25th, 2023, that one of those family members, Jennifer McCabe, who's the subject of great interest in this case and a primary person of interest in this case, is invited to Trooper Proctor's personal home for some sort of off-the-books meeting. Do we know about this meeting? Because Trooper Proctor, upon learning this, that Jennifer McCabe was coming to his house, ran back to the office and filed a police report, a supplemental report explaining this meeting, this off-the-books meeting. No, he never disclosed it. We found out about this because a concerned citizen happened to photograph Jennifer McCabe's car parked outside Michael and Elizabeth Proctor's personal residence in the evening after hours. And the best that counsel for Elizabeth Proctor can muster in terms of an argument is to say, well, you know what, Your Honor, maybe he wasn't home. Maybe, or maybe not. The suspicious part is Trooper Proctor isn't saying. And there's nothing in Elizabeth Proctor's motion to suggest that he wasn't home. Certainly his car was there. Elizabeth Proctor's car was there, and Jennifer McCabe's car was there. Was Trooper Proctor home? I guess I would answer that by asking the question, does it matter if Trooper Proctor was home? They've now admitted that Jennifer McCabe, a central character in the middle of this investigation, in the middle of this crime, was secretly meeting and or socializing with the lead investigator and or his wife in the living room of their home. And that, Your Honor, is a problem. And it shows more than a
Yeah, okay. See, I didn't know about this either. I did know, Cuppy, maybe you know, I'm going to have to dig into research on this because, like I said, I've seen bits and pieces over and over again from the first trial and stuff. So I get kind of mixed up now, especially now, where it's almost, 9 months later of the second trial, which was from the first and which was from the second one, unless it's from someone I know didn't testify in the second trial. But we know that Jennifer McCabe and Carrie Roberts went over to, was it Link's house? I think it was it was one of they were supposedly dropping off somebody there. I'm going to have to go back and check it all. But I do remember specifically in Jen McCabe's testimony, them going over how they went to this house, one of the officers' house, but they weren't seen. But I don't think it was Proctor, it was someone else. So this would be two different officers' house they went to then and made it. Oh my God. I'm going to have to go back and look. I want to go check it right now while this plays a little bit.
Professional connection. It shows a personal connection. And according to the Proctor family's own counsel, Elizabeth Proctor's counsel, the subject matter of that meeting was commiserating about this case. They weren't talking about sports. They weren't talking about the weather. They were meeting about this case. So how does that not show a bias, and how does that not implicate Karen Reed's constitutional rights to this information? And to this day, the Commonwealth has yet to concede what obviously is now sort of front page news, that there is in fact a personal relationship between the Proctors and their second family, the Albert McCabe family. But here's what the Commonwealth has said, even though they haven't made that connection or that concession. On October 3rd, 2022, Mr. Lally made a couple of points, eloquent points in this courtroom. And what he was doing when he did it in October was illustrating what an inappropriate relationship would look like if one existed, what a conflict of interest would look like if one existed. And he said, quote,
I don't think it was Proctor either. I think it was Officer Link, and that's what I'm trying to find right now. So bear with me 1 second. I'm actually going to leave it paused because I keep getting distracted by what Alan Jackson's saying. So bear with me 1 second. Oh, look at this. I think someone that was helping me look for all the pretrial has just found all of the pretrial motions. Oh, yay. So now we can go through them all. I'm so excited. Angie M., you are awesome. All right, bear with me 1 second. So I'm going to just search it up, who she went to. Hey, Fresh Brown Eyes, how are you? Okay, so you totally missed. I mean, you guys probably have seen this first trial and pretrial motions. I have not. And Cuffy, I think, hadn't seen it either because she was as shocked as I was. We looked at it back at the beginning of this, and I'm going to, if you're there and you want to see this, I think it's freaking hilarious. I'm going to rewind it for you because I'm still looking up some stuff. And Angie just sent me all the pre-trial stuff in one place, so which makes it so much easier, and I'm so thankful to her. You are awesome, Angie. Okay, so you got to hear. Tell me, Fresh Brown Eyes, if this is anywhere, because I have not seen this as much as I see on our server and that. Okay, so tell me if you've seen this anywhere, because I have not. This is freaking hilarious. Hold on, it's right before. Let's go right before she comes in. Okay.
Good morning, Mr. Jack.
Okay.
Today, I know that you're out of the country. Thank you. All right, so we have 4 sets of motions. The first one that I would like to address.
Free my boy Tipsy.
Free my boy Tipsy.
What was that, Jim?
Hold on, it gets better.
I think it was somebody on Zoom.
Nobody can speak, so it only could have been maybe, I think we're all set.
All right. So the first motion I'd like to deal with is the defendant's motion for Rule 17 records directed to Jennifer McCabe, Trooper Michael Proctor, and Elizabeth Proctor. Who's arguing that for the defense? All right, I'll hear you, Mr. Jackson.
Free my boy Billy Tibbetts. Free Billy in the trap.
Kevin, could you just be either mute or watch us?
Jim, that's not me. It's somebody else is saying, free my boy Billy Tibbetts. It's not me.
You gotta love when people
Okay.
tonight.
Thanks, Mr.
Yeah.
Whittington.
Thanks.
Well,
Go ahead,
listen
Mr. Jackson.
Right now.
Kevin, that was you.
Good morning, Your Honor, and thank you for giving us the time to
on.
address the court on these summonses for the third-party communications. I think I can cut this relatively short, given the Commonwealth's position that they are in agreement that the summonses for these third-party communications should issue. I want to save some court time.
Billy's innocent.
All right, so we may have to cancel Zoom for everybody if this keeps up. We will have to cancel Zoom for everybody if this keeps up.
I think I got that person, but.
Fuck off, Beverly.
Go ahead, Mr. Jackson.
Thank you, Your Honor.
Hold on. Here you go.
And
Gotta hear it again.
Cancel Zoom for everybody if this keeps up. We will have to cancel Zoom for everybody if this keeps up.
I think I got that person, but.
Fuck off, Beverly.
I can't. Fuck off, Beverly. That's too fucking funny. I can't. Oh my God. Did you hear it? I never heard this. Okay, see, I never heard it either. I didn't even hear people talking about this at all. I didn't. And oh my God, this being the very first hearing that I'm playing, just when I heard that, I was thrown aback. I was like, wait a minute. Did I just hear what I think I heard? It was so fucking funny. I thought, it's perfect timing that this person called Auntie Bev for what she was way before the first trial even happened. Like, just crazy. I mean, it gave me a really good laugh today. Okay, so I'm trying to look this up, and maybe you can help me. Tell me if you know, because this part that we were back on was him talking about how apparently Jennifer McCabe went to this is where it's talking about Jennifer McCabe went to Proctor's house and is testifying or saying that she went there to see Proctor's wife. Now, didn't Jennifer McCabe testify to the fact that she went to Lank's house with Carrie Roberts? Wasn't it Officer Lank? That whole, oh, Carrie's a talker. Do you know? Because that means, if I'm correct about this, this means that she went to 2 different police officers' house to supposedly talk to the wife or drop somebody off. Yes, Lank, not Proctor. Okay, but listen to this. Listen to this, Fresh Brown Eyes. Listen, hold on. So I never knew this.
that there is, in fact, a personal relationship between the Proctors and their second family, the Albert McCabe family. But here's what the Commonwealth has said, even though they haven't made that connection or that concession. On October 3rd, 2022, Mr. Lally made a couple of points, eloquent points in this courtroom. And what he was doing when he did it in October was illustrating what an inappropriate relationship would look like if one existed, what a conflict of interest would look like if one existed. And he said, quote, Michael Proctor has been fully vetted, end quote. He said, there's no conflict of interest here because it's not like, quote, these people are socializing together, end quote. He said, it's not like, quote, these people know each other, end quote. And he went on to say, it's not like, quote, these are people that Trooper Proctor has been over to their home, end quote. The Commonwealth said that because these facts would surely illustrate a conflict of interest. They would surely illustrate an undeniable bias. And those comments, Your Honor, I would suggest have not aged well. And I would wonder at this point if the Commonwealth hasn't adjusted its stance, which is why the Commonwealth is now conceding that we're entitled to.
I think I fast forwarded too much. Hold on one second. I'm trying to get into it.
And there's nothing in Elizabeth Proctor's motion to suggest that he wasn't home. Certainly his car was there.
Okay, I went too far.
car.
Hold on. Listen to this, Restaurant. Okay.
In the evening after hours. And the best that counsel for Elizabeth Proctor this, that Jennifer McCabe was coming to his house, ran back to the office and filed
Right here. Okay. Hold on.
to
Okay.
be their second family.
Right here.
And if that weren't enough, we find out during the pendency of this case on September 25th, 2023, that one of those family members, Jennifer McCabe, who's the subject of great interest in this case and a primary person of interest in this case, is invited to Trooper Proctor's personal home for some sort of off-the-books meeting. Do we know about this meeting? Because Trooper Proctor, upon learning this, that Jennifer McCabe was coming to his house, ran back to the office and filed a police report, a supplemental report explaining this meeting, this off-the-books meeting. No, he never disclosed it. We found out about this because a concerned citizen happened to photograph Jennifer McCabe's car parked outside Michael and Elizabeth Proctor's personal residence in the evening after hours. And the
Okay. So there it is. Okay. Wasn't there an instance? Let's see. Hold on. Wasn't there an instance though where TB checked the license plate to see if it was Jen McCabe's and she was at Proctor? See, I don't know. I'm still in the process of going back through all of TB's old stuff. Like I said, I didn't start watching Turtle Boy until last year, right around the second trial. So he's got so much content, I wouldn't know. So that's one of the main reasons I want to do this, is because working on this group thinking video about the anti-Karen Read population and, ignoring things, that are literally common sense, or, it's boggling the mind. So that's why I was like, I have to watch the first trial from the beginning to end so that I see exactly the things that went down. And when I started, I actually first tried doing it, watching Turtle Boy's coverage. But his coverage is kind of spotty because he's in court, out of court, and talking about what happened. I want to actually see what happened. So that's when I decided, well, if there's anybody else, I'll make it fun for myself instead of boring sitting at home doing it myself. I figure I'd stream it, and anyone else who hasn't seen it or wants to rewatch it can join me, make it a little more fun to watch. Some of these things can get extremely, extremely boring. But this has got me already. I mean, this is literally my first stream starting about this trial, and the very first clip that I play, or motion that I play, has already issues that I have never seen before. First of all, I mean, that's not really an issue, but I think it's freaking hilarious that someone told her to fuck off, sniped the Zoom meeting, and said that. And then already within the first 20 minutes of Alan Jackson arguing, is finding out another fact that I didn't know, that Jen McCabe was fraternizing basically with the Proctor family in the middle of this case. Like, I don't get it. And before you came, Chris Brown Eyes Cuffy and I were talking about, because prior to this he was talking about their relationship, and that they do socialize and this and that, because what I was saying is that these people, all of them, made themselves look suspicious, for lots of reasons. But one of the biggest reasons is right away, every time they're asked about their relationships with each other, they downplay it. They don't say, yeah, they're like my second family. Yeah, we spent time together. Yeah, they were in my so-and-so's wedding. Yeah. No, every single one of them lies about how close they are. And it's insane. So crazy. So now that I've got this lovely playlist from Angie, which I'm so excited. She's so awesome. I love her to death. We are going to start from the beginning. I'm sure this is in there somewhere, so I don't want to play it now and then go over it again. But I'm glad we started with this, because it's already got me so interested now. I was worried that I'd be bored, that I saw too much of it, but I can tell you right now, that's not the case. If in my first 20 minutes, I've already seen things that are first going to make me laugh, and others are going to be like, how did I not know this? Because they made a big stink about, that visit to Lank's house. And yet I heard nothing about this visit to Proctor's house. So for people like me who did come into the, the Karen Reed trials and the Free Karen Reed movement late, it's going to help to see some of this stuff, to really put an understanding for those of us who never saw or, weren't there in the beginning. So, okay, so you said TV has talked about it a bunch of times, and the person who checked the license plate and ran it got in trouble. Oh my God. I put your comment up there and I didn't even read it because I was mid-thought. I get distracted when I do that. Wow. Okay. So I'm definitely going to have to go searching his videos for this because I'm very intrigued about it now. It's crazy though to think that, I already said it really. It's just crazy. They downplay their relationships with each other. They're all related to cops or married to cops or are cops. And yet they think it's okay in the middle of a murder investigation to go visit each other's houses, to sit in rooms with each other, even if they were just witnesses. But I would think, and most cops would have thought, they were persons of interest at least because they were there on the scene where he was found. And to have them from the very beginning, for it to be okay for them to be in the same room, to get, their story straight, sit down and do timelines and, and then especially visit each other's houses and offer each other, them gifts. It has boggled my mind since I first got into this. And I can't believe some of this shit. I truly, I'm not the only one, obviously, but it bugs me to the point where I try to make sense of it and I literally can't even put a singular reason why they would be, anybody in this Commonwealth would be okay with what they've done, regarding this investigation. Wow. Okay. So let's see. They think they're untouchable. Of course they do. Of course they do. And that's because they had all their family were cops. They were all cops. They all were taking care of each other and thought that everybody in the position to do anything about it could help them out or shove it under the rug. Let's see. Said on the stand, I went to school with a girl. Yeah, I know. I did see that. Yeah. That's not even downplaying it. That's flat out lying. Like I can't remember who made the comparison, but the first time I saw it was when they were making the comparison, like saying, do you know your mother? And saying, oh, well, I know somebody who was married to my dad and lives in the same house as me. Like, are you kidding me? Is it a joke? I went to school with a girl with that. Yeah, right. Let's see. So you saw both trials. And when I rewatch the stuff, I think about new stuff because it's all, yes. And that's exactly why I'm doing this. Because not only I haven't seen it all, I have seen the clips. And of course, as you know, in our Discord, you see all kinds of fun stuff and parody and this and that from things in the first trial. But I've seen it all first of all, I've seen it all out of context mostly. And second, I haven't seen it in its entirety. And I want to see what I missed so that I can truly get a grasp on some of the things I'm trying to explain and put into videos that I'm working on. And it's already a little bit more, it's not little, it's a lot more crazy already in the first 30 minutes of a pretrial motion than I ever expected watching this first trial would be. So I am going to pull up this lovely list she sent me. Bear with me a moment. Okay. One moment, please. That's not it. Oops, hold on. I'm telling you, I wish I had a Mac computer. I'm with Cassie G, where I hate PCs. They're not conducive when you're trying to move things from an iPhone. Okay. I think I got it.
It is a little bit broader than that, as far as it also refers to anecdotal experiences or things of that nature, which obviously wouldn't be contained within a study or wouldn't be contained within certain materials. So I'm sure counsel is well aware, and I'm not certainly saying that they're not, as far as what an expert can testify to and what an expert cannot testify to. But essentially, what an expert can testify to is facts that they personally observe based on testing or things that they do themselves. Facts in regard to things that are in evidence or things that the counsel reasonably expects will be put into evidence. But the studies themselves, any sort of anecdotal experiences that they may have had, or any sort of scientific literature is not something that is permissible to be admitted as an exhibit. So if that is something that they seek to talk about, the Commonwealth would submit that that's improper. You know, what they did in this particular case, sort of what their baseline of experience is, what their baseline as far as their educational background in order to form some sort of opinion based on the facts as the jury finds them, is certainly fine. But making any reference to, because it happened in this study, it must be true in this case, is something that's simply not permitted.
Okay,
If I may, just briefly,
sure.
Mr. Lally uses the phrase anecdotal experience. That's the first time I've ever heard that in this context. I don't know what he means by that. But if what he means by that is bringing into court something that the expert has done or experienced or has experience with, and then relating that back to his opinion or her conclusion, isn't that what he's suggesting Mr. Whiffen do with his in-court experiment? That sounds like an anecdotal experience, but that's just me.
Yeah.
I think we have to take this on a case-by-case basis and figure out what the experts are going to say. I don't know what anecdotal experience means. So I can't really defend against that because I've put hundreds, if not thousands of experts on the stand. I don't know that I've ever asked, can you tell the jury what your anecdotal experience is with fill in the blank? So I'm not sure what and I'm not being glib, I just don't know what that means. So I don't know that the court can adequately rule on it. I think this may be something that we wait until
So let's get the list of the experts. Take a look at the Commonwealth's the defendant's expert discovery to you, and you can raise it again.
Thank you, Your Honor.
Thank you, Your Honor.
So, Jim, let's say no action taken. All right, 27.
Okay, so I just have to say this too, because for anyone who ends up watching this later, and for you guys that are here right now, anecdotal means, and I'm going to read the definition off the website because I don't want to try and explain it in my own words. I always end up on the tangent when I try to do that. So, anecdotal describes information based on personal accounts individual experiences or hearsay rather than rigorous, scientific, or empirical evidence. So, right there, in the word anecdotal means that it's not evidence that's obviously, or, evidence or whatever he said, that's peer reviewed, that's scientific, that can be proven, that can be repeated. It's something based on someone's experience or something they were told, which is, yeah, okay, crazy.
I'll hear you, Mr. Lally.
Yes. So, Your Honor, this motion eliminates in reference to prohibiting reference to any federal investigations conducted by the U.S. Attorney's Office or the Federal Bureau of Investigations. So, to this point, the U.S. Attorney's Office has publicly confirmed that at no time has the U.S. Attorney's Office named any person or entity as a target. So, any sort of reference to, and essentially what they've stated throughout the course of, and I know the court has had a chance to review those materials, but what they state is essentially their investigation into some unnamed criminal activity or some unnamed crime or there's nothing specific to any specific person or entity that is contained within those materials. So what the Commonwealth is submitting is that any reference to the fact that those things occurred is therefore unfair, essentially biases against one side or the other based on that, and it really has no relevancy. As far as making reference to, if counsel at some point either side wants to make reference to testimony or statements, reports, things of that nature that were provided in the course of that discovery pursuant to the TUI, obviously that's perfectly.
Yeah, I don't know who zoomed in. I'll be honest. This is just someone's playlist. Let me see it. It's someone's playlist someone sent me of all the pretrial motions, and when I look at all the different videos from the motions, they're actually all from different channels too. So someone just clipped them from wherever they could find them and then put them all in one playlist, which is pretty cool. But yeah, it is funny. It's probably the funniest Lally gets, and he's so freaking boring. Oh my god. Although I do appreciate Lally's monotone voice way over Brennan's nail scratching voice. Oh my god, his voice is so awful. So yes, it's personal experience, not like analyzed data, prove something is generally the experience, right? Exactly.
Permissible, but it also can be done without making reference to where that item came from. As far as you testified previously in relation to some investigation on such and such a date, you spoke to a law enforcement agent on such and such a date, and you said this. So if it's needed for those kinds of reasons, as far as impeachment and whatever, that's obviously perfectly permissible, but any reference to that in front of the jury, Your Honor, is something that the Commonwealth would submit is simply impermissible and irrelevant to the facts as they pertain to this case. So for those reasons, the Commonwealth would ask that this motion be allowed.
Is there an objection to this?
There is. Your Honor, the Commonwealth's position can be basically summed up in their moving papers with the following sentence that they drafted. The proceeding would be unfairly prejudiced if the defendant is permitted to rely on the mere appearance or existence of a federal investigation, especially where the investigation was shaped and influenced by the defense. First of all, the defense does not and did not shape or influence any federal investigation. The federal government is more than capable, Your Honor, and I think the Commonwealth knows this, of making its own decisions and about its own investigations. Second, and just as importantly, the Commonwealth cites no authority whatsoever that stands for the proposition that the mere mention of a federal investigation prejudices state court proceedings in any way, shape, form, or fashion, and that's because there is no authority. That authority does not exist. But most importantly, and this is critical, it is going to be critical to
Okay.
give the trier of fact. This
Fresh brown eyes. I'll see you later. If you're, yeah, I'll see if you come back. If I'm still, I'll probably be on for a while, as long as I don't get too tired. But be careful when you go out to do your errands. Thank you for coming.
jury, the proper context in which every one of the statements or every bit of the evidence is presented and how it came to light. It's essential for the jury.
How are you going to do that? How do you propose it? Is somebody from the U.S. Attorney's Office on your witness list to come in and talk about it?
There are federal agents. No. We don't anticipate presenting the fact that there's a federal investigation.
Isn't that what this does? If
No,
you mention it,
no. What this does,
explain to me why that's not so.
that's what I'm doing.
Not yet, you haven't. So please explain that.
As the court knows, it's essential that the jury is given the context in which every single statement, whatever the statement might be, is brought to light.
Does that mean, do we say in the prior trial that resulted in...
Oh my God, she's such a bitch. Shut up. You having the same thoughts I will. You know, I know you don't watch the Turtle Boy stuff, and I don't know if you've gone and looked at any of it yet, but he was arrested in the end of 2024 for witness intimidation, just for doing journalism. He went and asked questions because he truly, even then, believed in Karen Reed's innocence, and was looking at, if you don't believe she did it, then you believe that someone in that house did. So he was going after them as a journalist, asking questions, and he got arrested for witness intimidation for asking questions. And I mean, Cuff, one day you and I are going to have to talk. I will fill you in on all the details of that drama, because I mean the charges are bogus. There's proof out there too that they were just looking for something to charge him with, because John McCabe wanted him to go away. And but my point is, back to this, is when a judge cuts you off, not only once, but twice, 3 times, 4 times, when you're just trying to make your argument and you start getting into the for lack of a better term, meat and potatoes of your argument, and then the judge interrupts you again and again, it's absolutely ridiculous. Like, let him make his argument, listen to the argument, and then make your decision. Or then ask questions if you have questions. I just think it's entirely rude, and I know I'm not a lawyer. I'm not in the law profession in any way. So it's just my opinion. But I just think it's ridiculous that if a lawyer is making an argument to you, that I think that you should be respectful enough to listen to that argument and then ask questions, or then make a rule, or both, or whatever you need to do. But there was a hearing, Turtle Boy's most recent hearing, back, I think it was February 2nd, I watched, and his lawyer, who is Mark Batterow, and I don't know if you watch anybody or know who Mark Batterow is, wonderful attorney, he's amazing to watch on YouTube. But he, every freaking time, he would start getting into his argument regarding emotion or whatever that was going on, every single time that judge would interrupt him, ask him questions. And apparently that is what is known as a hot bench, because they had made that statement afterwards in an interview that it was a hot bench. And I never knew what that meant. And I guess some people have believed that a hot bench means that the judge was biased. And that's not what it means. It just means that the judge is overly, I'm not saying enough overly, they don't put it that way, in my opinion, overly involved, but truly involved in your motions and what you're arguing in the court, that they constantly interrupt, constantly ask questions, constantly. It's crazy. Crazy.
In a mistrial, you said this.
No, but But you would say, when you were speaking with Officer Smith or Officer Jones from the Canton Police Department at the Canton Police Station in this particular context, did you say this? When you were questioned by the Commonwealth's attorney in this proceeding, did you say this? When you were questioned by the United States attorney in this hearing, did you say that? That's what we do. Otherwise, it's perpetrating a fraud on the jury. The information that's gleaned during the federal investigation was revealed, Your Honor, importantly, by a neutral third party, a neutral body that's not connected in any way to this case. The Commonwealth has a stake in this case, very obviously. The defense certainly has a stake in this case, but the federal authorities have no stake in the case of the Commonwealth versus Karen Reed. Thus, the evidence procured by that neutral agency, which is independent of the case, is subject to a different and completely different level of scrutiny, a completely different level of assessment by the jurors. That is an important fact. There is no other way to truthfully and honestly present this evidence to the jury. Think about some of the questions that the court just posed. What were the circumstances in which you changed your testimony, sir? He's going to say, well, I changed my testimony, potentially, when I was called before a federal grand jury and I was asked questions under penalty of perjury. Why did you finally admit certain things when you were confronted with additional evidence, ma'am? And where did that evidence come from? Well, I was called before a grand jury and I was asked, or I was interviewed.
Hold on, I gotta see what you said. Okay, so this is what it says for hot bench, LOL. Instead of quietly listening, a hot bench challenges attorneys, interrupts often, and probes weaknesses in each side's position. Yeah, and I'll be honest then, because especially in Turtle Voice, and well, I can't even say especially, it's in both. In Karen Reed, you know that Auntie Bev was, was definitely a hot bench. And Turtle Boy's judge his name is Belazos, I believe. And it's weird. I don't know if you know this, Cup You, but if in Massachusetts, apparently, they rotate judges. So like through your pretrial motions and then, pretrial motions and your trial, if you go to trial, your judge is not the same necessarily. Whoever's on the bench when your date is set, so it constantly rotates. So they finally, because they were playing kick the can with Turtle Boy's hearings, literally every time he finally had a hearing, they'd have to postpone it, or it would just be some bullshit in the court, and then they'd make another hearing for months down the road. You're talking over, his charges have been going on for over 2 years now. It's insane. How they do things, and I don't even know what state you're from, Cuffy, but I'm in Michigan, and Michigan is not like this at all. And so it's another thing to see the way that the court itself works is crazy. Florida, okay. Oh, well, I'm jealous. You're probably nice and warm today. And we're having a heat wave up here at like 40 degrees. So that's what it is. But I don't see how judges can rotate through cases like that, because how do you rule properly or even retain the knowledge that you need to rule properly when you're not the one hearing all the motions and all the arguments? And I just don't get it. Crazy. But thankfully, Turtle Boy now has the same judge. Now, from now on, he finally he's with the same, one judge, finally. So, but he was a very hot bench, but he too seemed to only be interrupting Turtle Boy's lawyer, not the Commonwealth, that's a whole nother story too. I don't know if you know much about that too. The prosecution, the special prosecutors that they hire in that state, especially in that county, Commonwealth, whatever. I swear, crazy.
Interviewed by a federal agent, and I was asked or confronted with additional information, text messages, phone calls, etc. Or the third example, where did that additional evidence come from, officer? Text messages, phone calls, private communications. Oh, it came from a hearing in which I was questioned by a United States attorney under penalty of perjury.
Yeah, let me warn you, because the Turtle Boy stuff is, it's fun. I had fun going down it, but it will take you a long time. So, message me on Discord, and I will at least let you. I'll give you some insight on where to start because it's a lot. I'll tell you. It took me when I first started digging into who Turtle Boy was, and then watching his shows. Because he's a YouTuber and a journalist and a satirist, satirist, however you want to say it. He's funny. He's cracking up all the time. So he has a like a website where he does his journalism, his articles, he does actual articles and stuff, and then he does his YouTube where he's funny. But I'll give you some insight on where to start because when I went down that rabbit hole, I didn't know where to start. I just started watching his shows and I was so confused. I mean, I found them funny. So I'm glad I stuck with it because once I did, I met people through the chat who then directed me who people were and what to go watch and things to understand. And, but it took me a really long time.
In front of a grand jury. The jury's entitled to those answers in that context. If we were to do what Mr. Lally suggests, if we were to take that invitation, oh, well, you were asked by a prosecutor at a former hearing, XYZ, that would leave the jurors with the imprimatur of the idea that the Commonwealth elicited those questions, that the Commonwealth did their job, when we know, in fact, it didn't. The answers to those questions directly go to Ms. Reed's Bowden defense. Bowden talks about the inadequacy of an investigation. Obviously, Mr. Yannetti can talk more about that in just a second. We have information that a different agency was able to uncover information that the state investigation ignored. That's important. And it's important for the jurors to be able to weigh and balance that information and how the information came to light. If the truth is actually hidden from the jury, which is what the Commonwealth is asking the court to do, that the evidence was produced was the product of a third party, the truth being that the evidence was the product of a third party inquiry, unconnected to the state court case, then that jury is left with a false impression, false information, and it'll be unable to properly assess the true facts, which is what we're trying to get to, the true facts.
Hold on, can you hear me?
Why is the Commonwealth so intent on hiding the truth from this jury?
I had to switch my mic. Can you tell me if you can hear me?
I'll likely rule on that today. So.
Thank you. Oh, Mary B, hi. Sorry. My headphones were really irritating it. The way I had my hair up and my headphones on, they were starting to bug me. So I'm just going back to my internal mic. So everything sound okay? I'm glad you can hear me. I'm so glad to hear, Mary B. Oh my God. You missed the funniest thing. I have to ask you because I know that you've been watching this a really long time. So I can't stop playing it anyway because it's freaking hilarious. Can you just tell me if you've ever seen this before? Hold on. I got to go back to it. I know I can't because I always wear my hair up and the headphones always bump my ponytail and I get to the point where, okay, I'm done with them. But sometimes the internal mic on this laptop sucks. So, but I'm just streaming the trials and promotions. So I don't think it's a big deal. But I gotta play something for you because Fresh Brown Eyes was in here earlier and my friend Cup You here, she's from a different kind of universe on YouTube and she doesn't really know who Turtle Boy is. So thank you. So I've been kind of working her in and telling her a little bit, but I tell her she's got a lot of work to do to figure out Turtle Boy World. But there's one thing for me, not having ever seen the first trial or the first trial's motions. There's something I never even seen clipped before. So hold on, I'm going to pull this up, Mary B, and I need you to tell me if you've ever seen this. Hold on. God, my computer is so slow.
Good morning.
No, not that.
So as Her Honor was telling you, this is one of the 2 opportunities.
One moment, please. So much lore. Oh, I know. That's why I told her, I said, when I first started trying to figure out who Turtle Boy was and everything, it took me a really long time because what I did was went to his channel and just started watching him. And I was so confused. I'm like, who's this? Who's this? Who's that? And then when I finally went down the rabbit hole and started making friends in the community, okay, that's when I could ask people like, hey, who's this? And who's like I did the other day when I didn't know who Bert was or Brett, whoever that was. All I had to do was send someone a message in Discord, like, who is this? And someone could tell me. But when I first started, it wasn't like that. So it would just lead you down another rabbit hole. All right. How do I go back to my history? It'd be the easiest way to, oh, here it is, history, found it. I'm telling you, when people tell you that StreamYard is easy and some tell you it's hard, I'm like, it depends on what you're doing. The basics on StreamYard are very, very easy. But, you know, when you're sharing a screen and having to go to another screen and everything, I didn't realize how much I truly would need another monitor. And I had already planned on using a different monitor, a second monitor, but I don't have the correct USB cord to connect to my second monitor to my laptop. And I just haven't ordered one yet. And I really think I need to do that because this is not easy when you're going from screen to screen on the same damn computer. All right, here it is, I think. This is it. Yeah. Oh, no, that's not it. Okay, I'm from Worcester. And at least I know how to say Worcester, right? Did I say it right? Mary B, it's Worcester, right? See, I would say Worcester. Okay, yeah, because you're from the area. You knew who he was. And I'm sure you were, isn't it Jen McCabe who said, I did say it right. Yeah. I always worry because I know we have a lot of cities like that in Michigan too that aren't pronounced the way they look. Like Mackinac, everyone says Mackinac, and it's not. It's Mackinac. And I'm trying to. There's a lot like that. I'd have to look at them to think about it. But Mackinac is the biggest one, like Mackinac Island, and it's spelled ends in NAC, and so people are like, how is it Mackinac if it's spelled with the C? Like, so I get it. Okay, so I want you to listen to this, Mary B. And I want you to tell me if you ever saw this.
Good morning, Your Honor. Elizabeth Little, also on behalf of
Hold
Ms.
on.
Good morning, Ms. Little. Good.
I think it was right. Okay.
Motion I'd like to deal with is the defendant's motion for Rule 17 records directed to Jennifer McCabe, Trooper Michael Proctor, and Elizabeth Proctor. Who's arguing that for the defense? All right, I'll hear you, Mr. Jackson.
Free my boy Billy Tibbetts. Free Billy in the trap.
Kevin, could you just be
Free Billy in the trap.
mute or watch us?
Okay, so that's just the beginning, Mary
Tim,
B.
that's not me. It's somebody else is saying, free my boy Billy.
Somebody
Tibbetts."
sniped the
That's not me.
Zoom.
Okay, thanks, Mr. Reddington.
Thanks.
Go ahead, Mr. Jackson.
Kevin, that was you.
Good morning, Your Honor, and thank you for giving us the time to address the court on these summonses for the third-party communications. I think I can cut this relatively short, given the Commonwealth's position that they are in agreement that the summonses for these third-party communications should issue. I want to save some court time.
Billy's innocent.
All right, so we may have to cancel Zoom for everybody if this keeps up. We will have to cancel Zoom for everybody if this keeps up.
I think I got that person, but
Fuck off, Beverly.
I didn't.
I'm sorry, that cracks me. Fuck off,
Go ahead, Mr.
really. I'm sorry, it still cracks me up. I literally listened to that like 5 times. Look at Alan Jackson's face. Have you seen that anywhere, Mary B? I have not seen that clipped anywhere. I've not seen it talked about anywhere. And it's crazy because even though I've never seen the first trial motions or the first trial, it's in its entirety, and but how much parody I see, I have never seen that. Okay, haha, yes. Let me see what you say. All right, hold on. Okay, haha, yes. This was so funny at the time. It was one of the first inside jokes for the movement. Okay, I'll admit I was late to the trial one, just getting in on day 11. But yes, I remember seeing it. Okay, so it is out there. Okay, I just wondered if no one picked up on it because, I mean, yes, it was a long time ago now in this movement. But with all the stuff from the first trial that floats around YouTube and the parody and all this stuff, I am surprised that I have never seen this or heard about it. So it was so funny because I wasn't expecting it. Here I am. I'm watching the first trial and doing it this way so that it's not boring sitting at home doing it by myself. I figured, a couple people come in, want to watch a certain person that they haven't seen, or if someone else hasn't seen the entirety like I do and want to watch it, I figured it'd be more fun, even with a couple people. And within the first 20 minutes, actually, this one especially was in the first 5 minutes of me playing the very first video to watch. And I started cracking up. Okay, let's see. You almost forgot about it. Okay, the free Billy Tibbetts thing definitely got a lot of action. Okay, so you're gonna have to fill me in on who Billy Tibbetts is. So now I'm gonna have to go find out because it cracked me up so much. I couldn't believe it. And then, you know what else? Fresh Brown Eyes. I showed her this too because I couldn't remember for sure that Jen McCabe testified about being at Lank's house. Officer Lank's house, and that whole Carrie's a talker, she was probably 45 minutes. Well, in this motion, in this one too, he talks about how not only that, in September of 2023, Jen McCabe went to Proctor's house, and Fresh Brown Eyes was like, yes, apparently Turtle Boy had sent the person that took a picture or saw her license plate to see if it was her, and it was. And I haven't seen, I still have so much stuff of Turtle Boys saved to to go back and watch because there's so much, but I never saw that either. So I didn't know about this, especially with her having testified and them being able to bring up in the trial that she went to Lank's house and sat there, but yet here she also was at Proctor's house. Yes, she got fired for running that plate for him. Oh my God. See, that's awful. Oh, I feel bad for that. But yeah, it's not but. I feel bad that she got fired for doing that. That's terrible. Especially after all these assholes still have jobs for all the shit they've done. That's just bullshit. But I didn't know that she was caught at Proctor's house either. I knew she was at Lank's house because that was in the trial. But already in this first motion of watching from the first trial, him talking, Alan Jackson, talking about how you know, of course, I went into this earlier, how they all back down from, you know, admitting that they're all close to each other and how that's already an issue. And then you hear this, that she was at Proctor's house too. It's insane. I don't know how, I mean, it's simply put, I don't know how any of this is possible. And I've been saying that for a long time, and it just keeps getting added. There's another thing I find out, and another thing I found out, that these people got away with doing shit like this. Like, no cop in Michigan would stand for any of this shit. None. All right, so I'm going to go back to, let's see. Exactly. Let's see. It's not against the law to run a plate. Yep. They didn't really have to defend it because Bev didn't even let it in. Exactly. And see, that's why I think it's bullshit that she didn't let it in. That's why I was listening to that motion, but I didn't want to finish it because Angie found me the pretrial motions in order. So, which was awesome. So I figured we'll get back to it when, you know, that one comes up. But I thought it's crazy that I didn't know her about that either, for people like me who came in the second trial and, or even in the first trial, and didn't watch these pre-trial motions and know that it wasn't let in, that he, you know, that she was caught there, and knowing, and I mean, you know, having known that she went to Lank's house and they made a big deal about that, you know, her having done this with more than one cop's house isn't, I think it's relevant, but that's my opinion. Bev was a gatekeeper and had no oversight. It was frustrating. Yeah, for sure. Yeah, I could spout off for the next 20 minutes about how I feel about that woman. Hey, Mary B, is Danny live? I thought I saw Danny go live. Is Danny live? There was so much stuff that blew my mind throughout the first trial. It's almost impossible to list it all. Yeah. And see, and that's exactly why I felt it was necessary for me to go back and watch it. I just had to. Like, there's so much, and already, like I said, already in one video, I could see how much you missed if you didn't watch it. It's crazy. You've watched it 3 times? Oh wait, the second one 3 times. Wow. I mean, Alan Jackson does put on quite a performance. I don't think I could get through the entire second trial more than once, because the first time was bad enough, because Brennan's voice is literally like nails on a chalkboard to me. I cannot stand it. Oh, I got something to play for you to make it a little fun. Cup you. I told you about this the other day, this video, but I'm going to play it for you. Hold on. No, I'm not sure what he was doing, but he didn't go live. He will probably pregame around 6 or 7. Oh, okay, unless he's busy with family. Gotcha. So then I just thought pop up. So he probably set it for pregame for Turtle Boy. Gotcha. I see. I was like, I just saw it pop up in the corner of my computer. I'm like, wow. I was like, he never goes live in the day. I'm like, damn, I'm missing it. Were you watching Kazi G last night? I need to find. Okay, here we go. I watched somebody fall asleep. So did I. But I did see a lot of it because he got copyright struck by Sony, so it's gone now. Yeah, exactly. Were you there? I had woke up and he was talking for about 2 minutes, and within 2 minutes of me waking up and watching him, I think he fell asleep. So I've been telling everybody, you missed Kazi snores. Yeah, I don't think you're allowed to play music. I mean, I didn't know, to be under 100%. I didn't think you were allowed to play music that was copyrighted without getting demonetized, but I didn't know that they'd take it down. Oh yeah, he did. He fell asleep. You could hear him breathing, and he had muted the video he was playing, so it was completely silent. All you could hear was him kind of doing the breathing snores like Turtle Boy did that one. It was funny. All right, Copy, let's really watch this. I told you about these 2 songs that are hold on. My stupid computer. Come on. Okay. The channel Fervent does AI music videos that regarding the Karen Reed, and it's freaking hilarious. And I want to share these with you.
I've been biting my tongue for so long. Fuck you, hey. Think you're better than me. Fuck you, hey. You are not lolly. Fuck you, hey. Think you're better than me. Fuck you, hey. But why don't we see? I'm a basic kind of guy, I really don't need to flaunt. Smoking 6 packs a day and I'm happy as a hog. All I do is mumble, do I really need any lungs? The trial 1 jury was just like me, they were hung. Trial 2 came around and you wanna bench me? Not 1 guilty vote was embarrassing to see. Need to remind you that my jury was 9-3. Take your little OUI and get about the scene. Fuck you, hey, hey. Think you're better than me? Fuck you, hey. You are not lolly. Fuck you, hey. Think you're better than me? Fuck you, hey. Well, why don't we see? Oh, I know what will get us the win. Ask Rich about his fucking ham sandwich again. That'll prove this beyond all reasonable doubt. Oh, who am I kidding? This shit is a rout. You took this case so damn personally, and I hold that opinion to a scientific certainty. You weasel face, fuck bet, Arkham Major P. Even with all the help you got from Beverly, standing ovation. What a robust cross. Psych. Your nerdy ass looks so fucking lost. Just think, $500,000 was all it cost to get our asses kicked in the fucking law. Fuck you, hey, hey. Think you're better than me? Fuck you, hey. You are not lolly. Fuck you, hey. Think you're better than me? Fuck you, hey. Well, why don't we see? Why don't we see?
Hey, how'd that case with the middle school teacher go? I hear you're taking more L's than the Commonwealth.
Hey! Waiting for your response, Maggie.
Yeah. I told you. I knew you'd get a kick out of that one. Oh, just wait. There's one more that you got to see, Cupu. It's freaking, he's awesome. I'm going to, Hank was the worst. I know. I cannot stand his voice. That's why I will have a hard time if I end up wanting to go back and watch the second trial, which I'm probably going to do, but I literally cannot stand his voice. I can't. I'm putting his, I don't even know how to share a channel. But I'm going to put his thing in the chat. Hold on. As soon as I find it. I know it's Fervent Haas, but I don't know if it's capitalized or not. I think it's like this. So you have to check it out, Cupu. It's whole. He just makes the funniest videos. But I got one more for you. Hold on. Oops. I don't know, I'm having a problem finding just it. I found his jam session. Hey, Mary B, do you know what the Lally's version, the song is called? Oh, never mind, I found Hank Spanks Back. Okay, hold on, I got it. Oops. Yeah, Mary B, I can't wait till you start. Have you done any videos yet? You did? You started writing a Karen Reed musical? Oh my God. I cannot wait. I love these things. I don't know how. I wish I'm learning. I just downloaded and started using CapCut, for heaven's sakes. I used to literally stop and start recording using my freaking screen record on iPhone. That's what I would do. Because I don't, and normally I'm pretty quick at picking up software, and CapCut, I literally used it for the first time yesterday and I'm already addicted. Like, I'm like, why didn't I start using this a long time ago? Oh my God. But I'm not good with the AI stuff so much. Yeah, I've tried. I can make pictures pretty well. But trying to do videos, I have Canva, and I've tried to make videos and stuff that are more than 10 seconds or whatever. And I have a long way to go on that part. Let's see. Do either one of you have Discords or know any other good ones? I have made the ones I run for creators number. Oh, I just made my own Discord today, Cup. I will send you a link right now. Hold on. Mary B, did you get mine? Did you get my friend request to my Discord that I made? I think I sent you one. Yes, I joined. Okay, cool. Yeah, I'm still getting used to Discord too, but thankfully everybody, when I joined Danny's Discord, it was pretty much the first time I used it, besides getting game links for some of the games I played. That's all I ever used Discord for. I never interacted with it much until I joined Danny's. But building my own now, I'm kind of trying to have fun with it. So but I'm sending you a friend request for my channel, or my Discord channel right now. Copy, you give me 1 second. There, I just sent you an invite. You're the Discord queen. Okay, good. I know who to go to if I have issues. All right, so we're gonna listen to Hank Spanks Back. So you wrote, okay, wait, I wrote the songs for the musical like a year ago. Oh, I stopped because I couldn't get the duets to sound right and I couldn't afford the subscription. I gotcha. Yeah, the subscriptions are very expensive. I am on my free Canva right now. I used the 2 other ones that I used the free trial and I didn't like them. So I'm back to Canva now, and I downloaded onto my laptop. So I got another free 2 weeks or whatever they give you. So I'm hoping that by then I'll decide if I really want to pay for the subscription or not. But I can't wait. I can't wait to see your musical. Oh my God. Oh, I'll be so excited. All right, here we go, Copy You. I know Mary B's heard this, but here you go.
Today we say a prayer for Adam Lally, the once mediocre prosecutor who stayed mediocre.
hear our prayer. In the words of Auntie Bell, speak up loudly. Got a $500,000 cause of your incompetency. Calling me a nerd with creativity. Your shit was boring just like your delivery. Your monotone ass can't demand more cash. Only idiot to use a hung jury as a brag. A lowly ADA, so you must be a hack. You don't wanna see me get spanky on the track. You ain't good enough to have a private practice. You ain't smart enough to hide your malpractice. I was the star, you were like a fading actress. Hope Welcher spread his load all over your mattress. I know a lot of times that raps be fiction, but really let these next 2 bars sink in. You ain't skilled enough to get a conviction, even when in a corrupt jurisdiction. As for the aftermath, well, I'm making more cash. As for you, I think I saw you on DoorDash. Man, I kinda feel bad, sitting back with a laugh, counting up on my stacks. But let me end this quite plainly, just in case that your memory's hazy. It was confirmed on the stand that you're lazy when Rosemary made you her baby. All they wanna baba, spank. All they wanna baba, spank. All they wanna baba, spank. All they wanna baba.
Oh, is there, I think that's it. Yeah. Like that one? Oh, it's so awesome. There's one more now because I just saw it. I almost forget about this one. There's one more that I think that you'll get a kick out of. Yes, go subscribe because it's awesome. And he deserves the subscription. It's makes some great stuff. There it is. Since you know the case so well, you'll
Practicing fighting? Right. Did you see them kind of square up in a fighting stance to each other?
Started the wrong one. Hold on.
Practicing fighting? Right. Did you see them kind of square up in a fighting stance to each other?
Yes, Mary B, your mod. Thank you. You don't mind, do you? Because I can finally make mods. I forgot to do it the other day. And so when people come as they come in, I'd like to do that, to have a few people. Thank you, Mary B, and thank you for for doing it too. I knew you had said you were okay with it already. Thank you guys. All right, here we go. Cup you here. This one you'll get a kick out of too.
We believe that we can unlock an iPhone with our ass. We believe that medical science is a bunch of crap. We believe that Sir Isaac Newton doesn't know shit about physics. We believe that Celebrite sometimes makes up timestamps but still is the best in the business. We believe that it is acceptable to rehome your family pet of 7 years. We believe that when we are harassed, that's the only time we shed real tears. We believe that we love John O'Keefe, but our group chat showed no compassion. We believe that sometimes you slip on ice and land on your knuckles. Don't you hate when that happens? We believe in providing law enforcement with specific text strings that make us look good and then destroying the ever-loving shit out of our phones. I'm not done. And then taking that destroyed phone and dumping it on a military base. Totally normal. We believe in manipulating people when they are most vulnerable. We believe we have to tell each other what to say to Channel 4, even though it's supposedly the truth. We believe They're dumb enough to believe that John's injuries came from an SUV. We believe that if we put a billboard up, we can shift the narrative and point the finger back at the woman who was acquitted twice. We believe in disgracing the memory of a law enforcement officer and turning his tragic death into the biggest spectacle. Now shut up, look the other way and give us money! House defendants.
Yeah, he is. Very good looking man. And, you know, he was an officer, and no one deserves to die an unnatural death. And that's what gets me sometimes when in our community, Copy, you don't know it yet. And if you end up in our community, you'll see a lot of good stuff, but you'll also see a lot of bad stuff too, which is sad. And some of the people that are in this community now that have split it and divided it and turned into freaking monsters or fucktards, as I call them, because that's my nickname for them, because that's what they are to me. They just like to spread hate and negativity, and I think there was enough hate and negativity and stuff that day that he died. And that's what this is about. All of us, I think, that are still in this community for the reasons that we came into it, and seeing an innocent person persecuted for something they didn't do, and seeing the people that are most likely guilty getting away with it, it's devastating. And I feel horrible that this man will most likely never get true justice. It's unfortunate. All right. So, with that being said, I wanted to go back to the pretrial motions. But bear with me a moment, because there was something else I was going to go find, and now I forgot. Oh, I know. This was something for you to watch, Copy, just to give you a little bit of insight into Turtle Boy. That's what it was. Hold on. Okay, here it is. I got it. Okay. Mary B., if you're still here, I know you'll get a kick out of this one. Wendy Adelson needs to be prosecuted, in my opinion. I agree. Oh, here's Turtle Boy's song in the musical, if you want to play it. Oh, yes, okay. I do. Hold on. I'm going to play this first real quick because I have it up, which makes it easier for me not to have to go back to it. And then I'll pull that up, Mary B. Oh, I'm so excited to see it. Hold on. Okay, so before I play this for you, let me give you a little preface. There, like I just said, there are some people that are anti-Karen Read who believe that she is fully guilty, and who we call this group of women the foreskins. And the Broken Baker, who is awesome. He's another one that I absolutely love. He makes me laugh. And I can explain how these people are to you one day. But if you go to his channel, it's the Broken Baker. He's from Denmark, but he covers trials, and he's so funny. But these group of women decided to start a channel they're anti-Karen Reed. It's called the Forensic Files, but spelled with like the number 4, FOUR. So, but hold on one second. They're, sorry. Oh my God. Okay, never mind. Sorry. My internet just went red instead of blue, but it didn't disconnect me. So thankfully, woo. Okay. Now I lost my train of thought. But anyway, these women like to just spout off about, you know, how they think Karen Reed's guilty and blah, blah, blah. And as I told you in the beginning, I made a short. I told you to go see that short I made about a guy named Kevin Lenahan. His nickname is Clevin. So these women are kind of the same thing. They believe that she's guilty and blah, blah, blah. So they just run their mouths about this crap. Now watch this. Watch this girl's statement about corruption in Massachusetts. And this is Turtle Boy's reaction to it.
Zero corruption in the case of John O'Keefe, in Karen Reed's.
One more time. One more time.
They understand the justice system.
One more time.
Which this blows my mind. There is zero corruption in the case of John O'Keefe, in Karen Reed's
Oh my
prosecution.
God.
None.
There is zero. None. No corruption. No. It's not like the lead detective was fired. Oh, bro, you can't be serious. Bro, this is why gingers can't vote. This is why you people, oh my God. You're ruined, Big Red. You just set ginger rights back like 50 years with that statement. Take a lap, girl. 20 push-ups. 20 push-ups, girl.
There is zero.
Oh, I love it. I love it. Hi, that Diana. How are you? Yeah, it's hilarious. Like that's Turtle Boy on his YouTube channel. I mean, he makes you laugh. It's so funny. And you know, it's funny because I was a redhead for a long time. And some of the women that are in this anti-Karen Reed and anti-Turtle Boy movement, you will find out when you go digging into this universe, think that he's a misogynist and he degrades women, blah, blah, blah. But, you know, he's not doing it to degrade women. He's making it funny. He's a satirist. He's trying to get people to laugh. And, you know, I don't take offense to that when he says, oh, no wonder gingers can't vote. You know, like, so what? I wasn't a natural redhead, so maybe that's why I don't take offense to it. But no, I think that most people realize it's a joke. But some people are very sensitive and cannot laugh at themselves. And just, it's awful. But that's the kind of stuff that you are going to get when you go digging in Turtle Boy's world. So you'll be doing a lot of laughing. All right. Oh, you were too, Copy. Okay. Oh, Mary B, you are right. Yeah, you know, it's hard to see. Yeah, on camera. Yep, it's burgundy. Okay, see, my hair is purple now, and I'm gonna be honest. I plan on going camera on at some point. I plan on going on camera the other night with Cuzzy, and Crispy Treat. But the other night I went to take a shower so I could redo my hair because I had it up and I wanted it down so I could go on camera, and I had no hot water. So I was like. And today I didn't even plan on going live, and I was just sitting around and I'm like, well, shit. People knew I was going to start, you know, doing the trial and covering the pre-motions and our pretrial motions and doing the first trial. And I really was like, I need to do it, just start it so I can get this over with because I really want to get this, you know, viewed the entire first trial. And so today I just wasn't even ready. I just was planning. I was like, I need to do this and did it got on within 1 hour of thinking about it. But you'll see my hair is like dark purple now. It's like dark purple, dark brown mix. But yeah, I was a redhead for a really long time. Let's see. I loved having purple hair, but it doesn't color grays, so I had to go purpley red. Gotcha. Yeah, I do have grays. Yeah, I had grays. I remember I was the girl who used to she did my hair for a really long time. I'll never forget. I was 26 years old. And this was after seeing her for less than a year back then. and she was cutting my hair, and she goes, do you mind me asking how old you are? And I'm like, I told her, I'm like, I'm 26. Why? And she's like, you already have gray hair. Like, oh, well, thank you for letting me know. Because back then my hair was like, well, my hair was red for most of my late teens, early 20s. And I went back to my natural light brown hair. And then I was going back to red. And that's when she saw, oh, you got some gray hair already. And I'm like, oh, great. Thanks. But in the last couple of years, I'll tell you, I really have gotten some grays, and they do shine against the dark purple. But I don't care. I really don't. You had yours a deep reddish maroon color forever, almost purple. Okay, see, I'm not the only one. I have a few people that in my real life ask me why I have my hair this color. And I said, because I like it. Why else would I have it that way? And I'm not the only one. Jeez. All right, Mary B, I'm trying to click this link. I can't click it. So how do I copy? Do you know how I can copy that link out of, or the text out of your comment? I don't even know. Purple Girls. That's right. That should be Purple Girls Club. I'm gonna make a category on my Discord for Purple Girls. How's that sound? I need to figure out how to. Hey, Mary B, can you send it to me in a message on Discord? Oh, here, let me try that one. Hold on. See, I can't click it. Oh, you know what? I bet you I know why. My StreamYard is still the free StreamYard. I have to wait. Everything that's cost so much money, I have to pick and choose what I want to pay for. It's insane how much this stuff costs. I didn't realize getting the full StreamYard was it's like $89 a month. Like, holy shit. I'm not prepared for that. It's going to be a while before I monetized and stuff. That's why I even bothered getting my PayPal QR link up there, because I figured, as my channel grows, if people want to give me comments or donate to help me, do some of this stuff, I got to have a way, because it's expensive. And I never truly understood how expensive it is to run a channel until I started doing one. Holy moly. Yeah. You can't get it even when you pay? Oh, okay. Well, that's good to know. All right. If you can send, oh, you did in my Discord. Okay, perfect. Thank you. Let me open my Discord. Bear with me a second. I know that's what I'm afraid of. Yeah, how much it costs. Yeah, but see, Mary B, you, I think that you'll be, I mean, I don't know if you're like me. I mean, I pretty much live paycheck to paycheck right now. It's sad. I was sick for a while too before Christmas. I think most of the chat rats knew that, to how sick I was. So I had to miss work. And so now I'm even behind on rent. I'm telling you, like when you live paycheck to paycheck, it's awful, because if you get sick and you miss work and you this and that, and because it was the end of the year, I had no PTO days left. And it's awful. I mean, it's sad. One paycheck you miss and you're screwed. So nowadays, everything's so expensive. It's awful. So hold on. But yeah, like I said, I had no clue that all of this stuff was so expensive. I mean, I figured it all cost money. I mean, I had been using, like clip art programs like Canva for a while, but I always used the free programs. And when I started trying to figure out how much it would cost me, and then of course downloading StreamYard or using StreamYard for the first time, I was like, holy shit, $90 a month. Like, it's insane. I lost my job in October. Oh, I didn't know that. Oh, yeah. See, is a typo. Okay. I gotcha. Your question mark is a typo. I end up typing. I do the same thing, Mary B. I do that shit all the time, especially when I'm on my phone chatting. in the chat rooms because me and my stupid fat fingers, I have my dad's hands, unfortunately, the short, stubby, fat fingers. Okay. And I mean, even on my iPhone, I have an iPhone Pro. Actually, I have a Pro Max now. I just got it a couple months ago because I got the upgrade for free. And even with this big old giant phone, I still do typos all the time. All right. Oh, convict her. Is it this one? Okay. So I got two in here. So can I play them both, Mary B? Let's see. I followed the truth and it led to you. So let's start with this one. I've been so burnt out from work since the pandemic. I refuse to get a new job that's just going to burn me out. So it's been a process. Yeah. Yeah. I agree. I mean, I still work my full-time. I don't even work full-time. I work, it's considered full-time, but I only work 34 to 36 hours a week. But I work 12 hours midnight shifts. So I have a lot of free time when I don't work, you know, and, but I did too, like Mary B, I don't remember. Hold on. I think, hold on. I don't know if you were in the voice chat when I talked about this, but I, you know, with my psychology background, in the summer, I spent 20 years in the mental health field, in a couple of different jobs, but, in 2021, the summer of 2021, I got so mentally drained. I had to do something else. I had to get out of mental health, period. Like I had to just go do something else. So I went and got my clinical certified medical assistant certification redone. And I got a job working for an orthopedic surgeon and I love it. Like it's something I can take and leave at the job. When you work in mental health, no matter how hard you try, you take it home. And it just, during being through that during COVID, was probably the most stressful thing in my entire life. It was awful. And it didn't help that I was the only one, not the only one. I was like one of 4 people that still went to the office. Everyone else got to work from home. So that was even worse. Okay, so I'm gonna play this. I gotta share the screen. Hold on 1 second. Oops. All right, got it pulled up now. I'm just gonna share.
I wasn't some hero, just a guy with a blog, calling out scammers, exposing the fog. Little town scandals, parking spot cheats, the kind of stuff that rots at the feet. Then one night I get this name on my feed, John O'Keefe dead and Karen Reed. And someone tells me, yo, check this out. A Google search no one's talking about. How long to die in cold? Tell me, Jen, why'd you search that then? I followed the truth, and it led to you, to the lies you told, to the things you knew. You covered your tracks, but not well enough. I followed the truth and I called your bluff. They laughed at my tone, called me obsessed, but the evidence spoke and I never guessed. I dug through the photos, the files, the scene. It was messier than they made it seem. No tail light found where they said it would be. No glass, no
me. They said she hit him and left him to die. But that's not the story, that's the lie. I followed the truth, and it led to you, to the lies you told, to the trust you viewed, to the brotherhood blue, to what they conceal. I followed the truth and I made it real. Screenshots deleted, stories rehearsed. The truth wasn't missing, they just hid it first. You think I'm a joke, a man with no plan? I don't need a badge, I've got the facts in my hands. I followed the truth, and it led to you. You can smear my name, but the facts cut through. You buried the body, but not the proof. I followed the truth, and now so will you. I followed the truth, and I'm not done yet.
Oh, I love it, Mary B. It's got like Grease vibes to it. I like it. No, I more than like it. I love it. I cannot wait until you're done with this. Oh my God. It's going to be awesome. All right, let's play the next one. This one, convict her anyway. All right.
They call me Spanky, sharp as a tack, with a suitcase of bias and a courtroom act. I don't need proof or a witness who's sane, just a sprinkle of drama and a whisper campaign. The facts are confusing, the science is weak, then I'll crank up the volume and clench my teeth. Ignore that it's sketchy, dismiss what they say. I've got feelings, Your Honor, so lock her away. Convict her anyway. Let the truth decay. Who needs logic when you've got a good old-fashioned cliche? I've got taillights and tension, a narrative to play. So bring on the jury and convict her anyway. Ignore the cameras, ignore the crowd. I'll just shout a bit louder and seem more proud. Forget the misconduct, forget the lies. Justice is mine when the system complies. I'll twist every voicemail and act like I care, while the Fairview boys vanish into thin air. It's smoke and it's mirrors and courtroom delay, but the goal never changes, make Karen pay. Convict her anyway. Make the facts obey. If I shout and scowl enough, the truth might go away. With a fistful of fragments and vibes in full display, I'll dazzle the jury and convict her anyway. Oh, make the facts obey. If I shout and scowl enough, the truth might go away. With a fistful of fragments and vibes in full display, I'll dazzle the jury and convict her anyway.
I love the giggle. Oh my God. That's awesome. Oh my God. I'm so excited for you to finish that. It's going to be amazing. Did you yeah, it's really good. Oh my god. I love anything pretty much that makes fun of Hank Brennan. Oh my god. I have to get with somebody who I know Toy is so busy. I have been waiting for my rat suit. I can't wait till I get one, but I don't know who to ask. And I'm looking at your songs, and that's like, how did you write the lyrics? Or because they seem written, not AI. And I don't know how Toy makes those amazing songs. And here I'm looking at you, oh my God, it's so good. I don't know how to do it. I want to learn how to do stuff like that, and I don't know how to learn. Did you use, what, actually, let me just ask you, what did you use to make the song, and did you write the lyrics? Because I think they sound written to me, not AI written. I talked to JetPT. Okay, so let me see. I talked to JetPT for like an hour about the trial, and they wrote the lyrics based on what? Oh, okay. So see, yeah. I mean, pretty much, you had to feed the information, and so you knew the points that you wanted to make. So that's awesome. Like I just okay. So and then, what did you use to make the background music then? So lyrics, I get. Because I don't think if I were to do any sort of music, I don't know if I'd have a hard time or not writing lyrics. Maybe I would, but because I write poetry, I write my own poetry. I have since I was like 12. So I don't have a problem writing like lyrics and writing things, but it's the music. It's me. I'm not in any way, shape, or form good at writing or even know how to write music or begin to write music. So I think that's also another reason why I wouldn't even know where to start and what program to use to help with the background music. Because I did ask Toy what she used to make the videos themselves, and I know she uses Canva, which is another reason I went back to it. So you dropped the lyrics. Okay, into Sono. I don't know if that's how you pronounce it. I just downloaded Sono Friday, so I haven't really used it yet. I used it for maybe 10 minutes just to see what it was like. Very cool. I take advice from anyone who's been doing this for a bit. And those two alone, they're awesome. Have you made any videos prior to that? Any songs or videos before that? Because if those are your like the first couple that you made, a really good job. Very, very good. Okay, so just tell Sona what kind of vibe you're looking for, and they'll create a couple options. I just keep doing it until it makes one I like. Oh, cool. I'm going to have to play with it. Awesome. Well, it's good to know. Let's see. No, I think the Hank one was the first one I made. Oh, that's awesome. I made the Leslie one I really like. Oh, you did? Oh, I can't wait to see them. I'm so excited. Is the Leslie one on your page? I'm going to have to go to your page and look. I think I'm subscribed to you already, but I didn't even know that you had videos on there already. Because I know when I heard you talking about your page and that, you said that you weren't going to go live in the beginning of February, and then as far as I know, that you haven't. I haven't seen any. So I've been waiting. And waiting. Glare Bear, my fellow Glare Bear. Since we couldn't make Glaries happen, I'm bound and determined to make Glare Bear happen, especially since the idiots over there like to comment about how you stare. So funny. All right, let's see. I want to Let me see. Sorry, y'all. I'm in and out. Oh, okay. Here are some appear to be some update in Nancy Guthrie case. What a mess they have made of this one. Oh yeah. I don't even want to get into that. I'm going to be totally honest with you. It is really, really sad. And with how much time has gone by, I don't think it's going to be a good outcome one way or the other. And it's really sad. And so yeah, I mean, Cupu, thank you so much for being here. And if you come back in and out, we'll talk to you. I want to go through some of these motions, even if no one's here with me, because if I don't, I'll never get anywhere. But yeah, I'm so glad to have you, and I'll be looking for you when you come back. We're on the next one. Oh, you're covering it for 4 people? Oh, wow. Wow. Okay. Yeah. See, I don't want to get into that one. It'll just depress me. And, yeah, I'm not even going to get into that. There's enough depression and sad things in this world that can really make you down and out, and that one, it's really heartbreaking. And I truly pray that, for the best outcome. It's just, unfortunately, I just don't think that's the way it's going to be after this much time. All right. We'll see you when you get back. So let's see. What'd you write? Oh, I missed this one. So no, this stuff was all from like 8 months ago. I got all overwhelmed about it, but I'll get over it. Oh, I understand that too. It's very overwhelming, I'll tell you. Especially like I think, like those of you, like you, Mary B, you go up on Danny's platform, but you don't run the StreamYard. So it's very, for me, who's never been on a panel and never worked this kind of stuff, it is overwhelming. It is a lot. And even though I do pick up things pretty quickly, I'm a very visual learner. So normally if I see it done, I can normally Google it and watch a video once on YouTube about how to do something. I can normally then repeat it. But it's a lot. I mean, it's just from going from StreamYard and back to YouTube. And then of course, all the stuff in StreamYard to do. And then if you wanted to make content and like I said, I downloaded CapCut on my phone weeks ago, and I just opened it for the first time the other day. And I'm like, and then I, hit myself on the head and say, why didn't I do this sooner? Yeah, I have no idea how it works. Well, I mean, thankfully, you, like I said, you have a little bit because you've been on the panel and stuff. So you kind of see the ins and out of the screen. So all you need to do once you use StreamYard for yourself to start streaming and posting videos, you just have to maneuver how to put those things on the screen, which I think you'll be just fine at. But yeah, CapCut, I'm so mad at myself. I can't believe that I went that long with it on my phone and didn't even bother trying to use it. Crispy Treat was the one the other night, like, dude, just open it and then you'll be hooked on it. And that's exactly what happened. Like, I'm like, how did I not know about this? And why was I not using this before? I'm so dumb. Yeah, mansplain it. Yep. He'll do that for you. Well, the funny thing is that when I don't know if you saw my post when I first started deciding to actually do this. What I wanted to do was stream the trial. The first trial I posted in the Discord about how I wanted to do that. And I said, I need 50 subscribers. Hey, Danny, just talking about you. Ironically, your ears were ringing. But I had posted, I'm like, everyone, I need 50 subscribers so I can go live to run, to stream the trial. And Danny was like, hey, you don't need 50, you just need the free StreamYard. And I'm like, oh, sweet, thank you. I would have never known. I would have just waited until I got my 50 people and and then done it. So had it not been for him telling me, I had no clue. And I can't imagine all the ins and outs of this program that I don't know. I mean, I've only been live a few times, and I'm just knowing what I missed out on using CapCut for the weeks I had it downloaded and never used it. Like, I can't imagine the things I'm still missing on all these programs that I've now downloaded and haven't used yet. Yep. See, we were talking about you. You got to mansplain to Mary B how all this stuff works. What was I going to say? I don't even remember what I was going to say. It's just funny because I'm a procrastinator like that a lot of the times, especially when it's something completely new. Like I get, like you just said, overwhelmed. Like I'm like, I don't want to do too many new things at a time because then I'll just get frustrated if I don't understand it, and and I'll just stop. You didn't do anything bad. I know I already explained for me, but Mary B, we were talking about her going live and how learning new things, and she's making this musical about the Karen Reed whole trials and situations, and having to use StreamYard to start going live and this and that. And I told her how I didn't know all this stuff, and it's learning everything, all the ins and outs. I am a visual learner, so I just Google it, but it's still a lot. It is a lot to learn, and I still have a long way to go. I just realized that I don't know how to work StreamYard. I should probably get into it and ask you. Yep. Yep. And when you came on, that's what I was doing. I was explaining to Mary B about how you were how you had told me when I was posting in Discord that I'm like, I need 50 subscribers so I can go live to stream the first trial. And you're like, you don't need 50 people, just get StreamYard. And I'm like, oh, thank you. I would have never known that. Well, thank you for coming, Danny. It's good to see you. What time are you going live? Because I want to be off so I can join your pregame show. Oh, and I got one more question while you're in here, Danny. Do you use 2 monitors? You cannot select a destination and go in StreamYard to do work. And you can go live, but set to private and practice and rewatch to adjust your stuff. I did see you tell someone that. I think you were telling Kazi that, or maybe Erica Walsh when she was talking. I know I saw you say that to someone, and I actually have done that to kind of get used to some of these controls before I went on the first time. But it's still a lot. Like even if I do it once, if it's something simple, I can go back and do it, right away. But some of these things I have to go back, and I'm like, I need to make a note on how to do that because I'm not going to remember, because it's a little harder than just a couple clicks, especially going into like the other programs I was talking about, like Canva and CapCut and stuff like that. Oh, you got homework, Mary B. So there we go. Trying to find my stinging playlist I had ready for the pre-trial. I want to go back and finish this one motion. Oops, not that. Yeah, this one.
Rule on that today. So
Danny is
number 28.
That's right.
Thank you, Aaron. So again, Similar to the motion previous to it, the Commonwealth is not seeking to hide anything from the jury. What the Commonwealth is simply seeking to do is ensure that whatever information that's provided to the jury is actual admissible and relevant information and not the product of rank speculation. So this motion is seeking to prohibit reference to any pending internal affairs investigation or unfounded allegations of misconduct.
Oh,
And
since
really,
you guys are in here, I
primarily
got
what we're
one quick
talking about
question
here
before,
is
hold
any
on.
sort of
Let me pause
internal
it for a
affairs.
second. Because I know Mary B, you said you saw the first trial. I don't know if Danny, you saw the entire first trial or not, but I cannot wait until Tristan's testimony. The guy, the boyfriend, apparently is like, I don't know what time. I don't know where I pulled into the driveway. I don't know anything. He wasn't like, he would not commit to anything. So my question to you guys is, if you've seen it, then who else's trial or who else's testimony in the first trial is like that? Or who else is going to be really good? Danny's been here the whole time. Okay. So, yeah, I wish I would have found you guys sooner. I told Danny this when I first joined. The very first night I watched you guys' stream, both of you were on. And you guys, I was so excited. Everybody in the chat was awesome. I mean, I had been watching The Glare for a while, but it's a totally different vibe in his chat and channel than it is on yours. And I just felt so at home in your channel, Danny and Mary. Mary B. Right away, I just felt comfortable there. And I fell asleep to Toy's music and woke up to Toy's music that night. And it was just fun. I enjoyed it a lot. So, but again, back to my question, if you guys tell me which people I should look out for in watching the first trial for the first time. I know Tristan, I'm looking forward to Tristan's entire testimony. Yep, that's right. Colin and Matt. Okay. Tristan is the dumbest guy ever. You're right. I mean, I think I've seen enough of it to get, but I wanted to see his testimony specifically to see what else he says, because the clips that I have seen of him, it just was like, I'm just like, are you serious? Like, how do you not think this looks bad? Or how do you not think that you look bad by answering this way? When Yannetti asks him specifically, like, could it have been 9:30? Like, obviously not. But he's still like, nope, I'm not going to commit on a time. Nope. Mm-mm. Oh, yeah, Higgins, of course. Of course. Yeah, I can't wait. That's why I'm looking forward to doing it this way, because even if it's a couple people here and there, I have someone to go, bounce ideas off of or laugh with or whatever. Because if I sat home and watched this entire trial by myself, I would just get so bored and I'd probably just stop doing it. Even if there was certain things I want to look forward to, but I feel like getting into the things I wanted to get into for videos that I want to post on my channel, I really need to take in the entire first trial. Oh, Proctor, see, I forget about him already. I forget about him. First trial was all about the House defendants and cover up. The second was more scientific. Yeah. I think that's why this trial will actually be, whether I'm sitting here watching it for myself, I still think it would be a little bit, it wouldn't be as boring as trying to watch the second trial, or at least not. See, the second trial wasn't boring either, though, because there was a lot of fireworks with all the crap with the sweatshirt, and Brennan's talking about the ham sandwich for 3 hours, and oh my God, but his voice alone, I don't think I could possibly watch the whole second trial again because of his, just because of Hank Brennan's voice. I don't know if his voice affected everyone else the way it affected me. I know I've seen people, make fun of his voice, but it truly, like, I would sit here because I would watch the entire trial. I would sit there and be like, I need to go in the other room and not listen to his voice for 5 minutes just to like scrub it out of my head. And then I have to breathe in and say, okay, I can take it for another couple hours. Yes, the first trial is so interesting, but because of Lally, it's also so boring. Yeah. See, and I think that it's and that's it with the second trial, is that it's interesting. But it's also annoying. Not that it's boring. It's annoying because of Brennan's voice. Yes, exactly. He was so rude. He was snide and snippy, and just the tone of his voice alone is like nails on a chalkboard. Ugh. Well, thank you. Now I'm getting excited again about watching this thing. Because as I know, Mary B, you know that I've already learned 2 new things in the first 20 minutes of me when I was streaming this earlier. I cannot get over the fuck you, Beverly. That was freaking hilarious.
Investigation related to Trooper Proctor and the 20-something-year-old civil case, which resulted in no findings of liability that was referenced by counsel in their motion to dismiss with reference to Sergeant Lank of the Canton Police Department. Under the case law, including McFarland and Graham, the most recent case law, what they essentially attribute is that those types of information, when there is no finding of liability, there is no sustained finding of misconduct, there is no findings of liability by the party at question, that is simply not admissible. And so for those reasons, the Commonwealth submits that this motion should also be allowed.
All right, who's arguing this for the defense? And Ms. Little, what I need to know is what exactly you intend to introduce and how you intend to introduce it.
Thank you, Your Honor. I think it's somewhat premature for the court to rule on this issue. Obviously, the testimony of both of these witnesses is going to be highly relevant as to whether this particular information is relevant. We are still actually receiving information with regards to the internal affairs investigation as recently as yesterday. So I'm happy to kind of defer ruling to the court and then address this as it comes up. I think the court will be in a much better position to rule on this issue once the witness testifies.
All right, so what would be helpful to me, once you know what it is you think you're going to try and introduce, to tell me how that complies with the holdings in both McFarland and Graham.
There are independent reasons why that is admissible outside of McFarland and Graham.
Okay, so I need to know all of that.
Sure.
Okay.
Thank you.
So I'll take this under advisement. And how much time do you need to give me at least a general response now? Can you have it by Tuesday?
We can do that, Your Honor.
Okay. All right, so I'll hold off on that, Mr. Clerk.
Yes, Your Honor.
All right. So number 29, Mr. Lally.
So this motion, Your Honor, is essentially entitled Motion to Eliminate for Advance Notice if defendant intends to cross-examine any witness about alleged bias and request for a pretrial ruling on whether proposed evidence demonstrates plausible showing of alleged bias. So the Commonwealth is not stating that there are no statements, as the court is well aware, that could be interpreted to reflect bias and could be used by counsel in cross-examination. So what the Commonwealth is not suggesting, and bless you, is for any prohibition on any statements whatsoever. What the Commonwealth is seeking here is a ruling as to what precise statements the defendant seeks to introduce in regard to that, so that the court can make a ruling prior to the witness testifying before the jury as to exactly what's in play and what is going to be admissible and what's going to be allowed as far as obviously it's not a perfect world, and if a witness were to answer something in a way that would then open the door for further material to come in, that's understandable. But at least a preliminary showing as to exactly what the defendant submits are the statements they wish to introduce in relation to this issue.
Isn't the defendant given broad range and cross-examination as to bias?
Yes, and that's why I indicated early on that I understand that there is some, that there certainly is some areas that under the law, whether or not they're true or not, are able to be explored as far as cross-examination is concerned. But what this motion simply seeks to address is there are restrictions to that. It's not unfettered. It's not, just anything and everything that they could possibly think of as say as far as accusations go.
Is there any particular type of testimony you're concerned about? I mean, is there anything in particular that you say they should not be permitted to go into, based on what we've heard throughout the pendency of this case? Is there anything? And I'm reluctant to tie the defendant's hands in any way on cross-examination without knowing exactly what it is you think is improper.
Okay. And what I would do, Your Honor, what I would suggest is similar to the other motions that we spoke of before. I can provide a supplemental with more specifics as to what the Commonwealth's concerns are.
Okay.
If the court would find that helpful.
Yes, I can't rule on this as is. So is there any objection to that, Mr. Yannetti? You're nodding.
Well, no, I think that makes sense.
Okay.
It was Ms. Little's motion.
Oh, I'm sorry. I saw you nodding.
I don't want to step on her toes.
No objection to that, Your Honor.
Okay. All right. So why don't you do that? So,
Sure.
Mr. Clerk, will hold off on ruling on this until we get something from the Commonwealth.
Okay.
So Commonwealth will clarify. Right, and then no action taken. All right, so as you know, third-party culprit and Bowden are often argued together, often presented together. Why don't we just deal with the two motions together? So Commonwealth's file, you're number 30 and 31, Mr. Lally. Mr. Yannetti, are you arguing both? Does it make sense to sort of keep them together?
I agree that they should be kept together.
Yeah. All right, so why don't I hear you as to your concerns on both? And as you know, sometimes third-party culprit as it goes to Bowden is different than just straight third-party culprit. And actually, it might save us a lot of time. Is that what you intend to do, Mr. Yannetti? Third-party culprit as it goes to Bowden, or straight third-party culprit as well?
Definitely third-party culprit as it goes to Bowden, that's for sure. And then depending on how the evidence develops at trial, there may be, an offer to offer third-party culprit evidence with regard to third-party culprits. But I think I can speak further to that in response.
Mr. Lally, go ahead. You can argue these however you want to argue them.
No, and I would argue them sort of in that vein, Your Honor. So understanding that based on the state of the evidence, as I anticipate it to be, and in any case, regardless, I think a defendant in any criminal case has a much better shot, essentially, at getting evidence in regarding to Bowden as sort of a backdoor through, as to third-party culprit as sort of a backdoor through a Bowden defense. So what I'm primarily concerned with, Your Honor, is motion to eliminate number 30, because as the court is well aware, there have been a number of theories of sort of speculation, rank speculation, opinions without any evidentiary support, names of certain people that have been dropped at this microphone by counsel at different pretrial hearings who are not witnesses.
Hey guys, is 1.5 too fast? What do you guys think? Hey, Fresh Brown Eyes, it's good to see you again. Aw, thank you, hippie chick. I just don't know if 1.5 is
who
too
have nothing to
fast.
do with this case, who don't know anything about this case, who counsel, when they said those names and sort of dropped those, whatever they supported to be facts, knew that they had nothing to say and nothing to do with this case. What I'm concerned about is whatever is acceptable as far as believability when it comes to arguing things in pretrial motions, shouting things from courthouse steps, or bandying about on Twitter is not what we do here. And so now it is a time where counsel is going to be relegated to what is actual, admissible, relevant evidence. And what I'm asking for in this motion is for
Thank you, Hippie
the
Chick.
defendant
Not
through
too
a
fast
counsel
for me.
to
Okay,
actually
good.
provide
Yeah, he
any
definitely is
admissible
a
or
slow
relevant
talker.
evidence that pertains to third-party culprit, which
Okay.
to this point they have not done.
Thank
So
you,
if this
guys.
is something that's going to be raised as an issue on its own, as the court is well aware, what the case law indicates is that the acts of the other person are so closely connected in point of time and method of operation as to cast doubt upon the identification of the defendant as a person who committed the crime. It has to be specific. It has to be to at least a specific realm of person or a specifically identified person who would have motive, opportunity to commit the act with which the defendant is charged. And up until this point, I have not seen anything specific as to that. As it pertains to the Bowden motion the Commonwealth filed, what the Commonwealth is asking for there is notice and voir dire in relation to a Bowden defense. So if there is, again, going to be some, I don't think the evidence comes anywhere close to a Bowden instruction, but certainly what the courts have said over time is that a Bowden defense is something that if the evidence warrants it, counsel can elicit testimony in regard to it or attempt to and make arguments in reference to it. So I'm not seeking to preclude counsel from making arguments or from counsel asking questions. What I'm seeking clarification on is what exactly, and again, this is from a position of operating without any information whatsoever as to what a defense may be. And understanding that counsel was not required to provide any information until the Commonwealth filed its certificate of compliance. But there's been, regardless of whether they were required to or not, I'm going into trial on Tuesday without any information whatsoever as to who they've spoken to, what statements they might be, who their witnesses are, or anything of that nature. So for those reasons, the Commonwealth feels it appropriate to at least file a motion to be given notice as to exactly what the defendant intends to do. This trial by ambush is simply not something that's permitted by the case law, and that's what the Commonwealth is seeking to prohibit in that second motion. Thank you.
Okay. All right, Mr. Yannetti, I'll hear you.
Oh my God, I have to ask you guys that are Hippie Chick and Fresh Brown Eyes, have either of you been watching or have you watched it over now? He was found guilty, but the Paul Canero trial, the one where he was accused of unaliving his brother, his brother's wife, and their 2 children, and then setting the house on fire. No? Okay. I watched a little of it. Okay. So, my point in bringing it up was that Lally just used a term that the judge used against Paul Canero's defense attorney, who I watched a little bit of the trial on Mo and Deep End, her channel. She, I found her because the Broken Baker sent us there one day, and she was covering the trial, and she called, it's so funny because she calls the Paul Canero's defense attorney Timu Kim Kardashian because the way she dresses. And she, speaking of, she says and literally between every question and answer, and I just did it, which reminded me to say that. It was really, really annoying. And then, but the judge, she got caught hiding evidence from the prosecution, electronic data evidence, which you can't do. Hey, Mary B, welcome back. That's okay. But she got caught doing that and tried to sneak it in and then played stupid in front of the judge. And the judge was like, we aren't doing that. Oh, you did see that, Hippie Chick? Okay, so you know what I'm talking about. And that judge went off on her. Oh my God. Oh my God, it was freaking hilarious. So funny. But it just caught me because the judge used that term. This is not going to be trial by ambush. And Lally just used that exact same terminology. It just caught me off guard.
Thank you.
And though they're argued together, I do want you to also start with the third-party culprit alone, not
Yes,
third-party
it
culprit
is a real,
as it goes to Bowden,
yes,
but third-party
definitely.
culprit alone.
That guy's
Because
a
of
real
all those
judge.
factors that I told you, as you well know, the
He's
case law
doing
is clear,
things
that I have to
correctly.
consider. And if I had to do it now, and you know I can do a pretrial, right? You know that today I can just exclude it. I'm not inclined to do that, but I need to be able to make those decisions, to weigh those factors, because right now I have zero information on
Right, I
this.
understand that, Your Honor, and that was my plan going into today anyway. So the initial question is, why is there a third-party culprit defense? Why is it relevant? And we start, Your Honor, with the fact that our forensic medical examiner, Frank Sheridan, a forensic pathologist who has performed himself thousands and thousands of autopsies, has already submitted a sworn affidavit to this court that John O'Keefe's injuries are consistent with having been in a fight and are not consistent with having been hit by a car. Since he submitted that affidavit, the federal authorities have provided us with their reports, whereby FBI experts also corroborate that John O'Keefe's injuries are not consistent with having been hit by a car. They employed experts in biomechanics and kinematics who have reviewed the evidence in this case, and they've confirmed that the physical evidence essentially shows and doesn't show what Dr. Sheridan has opined. So therefore, if John O'Keefe was not hit by a car, that means that Karen Reed did not kill him. And we know that John O'Keefe did not die of natural causes. This was not a heart attack or a stroke. John O'Keefe was injured. He was mortally injured. If he was not hit by a car, as both our expert and FBI confirmed, then he was attacked. And if he was not hit by a car, then there is a third-party culprit or culprits. So by asking this court to prohibit the defense from introducing evidence that others had the motive, opportunity, and the means to attack John O'Keefe, the Commonwealth is essentially asking this court to prohibit Karen Reed from being able to defend herself.
So I don't think they're asking that you be prohibited from doing that. They're asking first to have you tell them what that is.
Right. Well, this is, Your Honor, I'm getting to that in terms of.
Right, so go ahead. You have your remarks.
That we are either required to give them or not. It is not our job to solve this case for the prosecution. It's our contention. They had the opportunity to do that, but they failed. It is not our job to name a specific third-party culprit. We do not have to prove that Brian Albert or Colin Albert or Brian Higgins or some combination of them intended to kill John O'Keefe. We don't have to prove that any of them attacked John O'Keefe such that he eventually died. They have to prove beyond a reasonable doubt that they didn't. But the fact of the matter is there is evidence that all three of them had a motive, had the opportunity and the means to attack John O'Keefe. Now, the Commonwealth cites Commonwealth versus Conkey in their motion, and as this court started the discussion on this issue when you first took the bench, Conkey makes clear that a defendant has a constitutional right to argue that somebody else may have committed the crime. And certainly, no, the acts of that person can't be too attenuated in time or method of operation, as Mr. Lally mentions. But in terms of being the right time period, Your Honor, you can't get any closer than their presence at the scene at the very time that John O'Keefe was killed. And in terms of the method of operation, given that we have evidence that he was not hit by a car and that he was attacked, all three of these men, either alone or in combination, possessed the ability to attack him with or without a weapon. I mean, it's a very low standard here. The Commonwealth acknowledges that. It's a low standard of simple relevance. And the evidence here establishes relevance. Now, I would note, Your Honor, the Commonwealth cites Commonwealth versus Finney. I don't know if they realize this, but that was my case. I represented Roland Douglas Finney before the Supreme Judicial Court, and I represented him at his motion for new trial and at his retrial. And that case, the Finney case, provides strong support for the introduction of third-party culprit evidence here, irrespective of a Bowdoin defense. In fact, the reason that Mr. Finney's conviction was overturned was that his trial counsel failed to pursue a third-party culprit defense. And Your Honor, the third-party culprit defense in Finney was weaker, far weaker than the third-party culprit defense we have here. The evidence of motive in that case was that the third-party culprit made derogatory statements about the victim after she was murdered. No witness in that case put the two of them together. No witness in that case put the third-party culprit at the scene of the murder where the victim was murdered. There was some consciousness of guilt evidence similar to what we have in this case. But in Finney, the SJC ruled that not only was that enough for a defense attorney to present a third-party culprit defense, but he was ineffective for not doing so. And as the court has also touched upon, the SJC found that on the basis of that third-party culprit evidence, which is weaker than what we have here, there were substantial connecting links between that third-party culprit that justified the admission of hearsay in that case. And I want to make it clear, we're not looking to introduce any hearsay statements, so we don't need substantial connecting links here. Now, Your Honor, I could go through with the court the specific evidence we have with regard to motive, opportunity, and means with regard to the three Commonwealth witnesses that I've named.
So go ahead.
Happy to do it. Starting with Brian Higgins. He was present at 34 Fairview Road on January 28th to 29th. He was close friends with the homeowner, Brian Albert. He had a prior romantic interest in Karen Reed. He did not expect Karen and John O'Keefe to be at the Waterfall, that bar, on January 28th. Karen Reed did not greet Higgins, despite the fact that they had previously exchanged flirtatious texts and that she had been at his apartment one evening, although there was nothing that took place between them any more than a peck of a kiss. At the Waterfall, Higgins does not engage with John O'Keefe. He does not say goodbye to John O'Keefe and Karen when he leaves, but before he leaves, he texts Karen, and that text was something to the effect of, well, with a lot of M's. We know that there was a preservation order from this court, your predecessor, Judge Krupp, to preserve his cell phone, and that Trooper Proctor gave him an edict an order to serve on Brian Higgins, and he left it at the front desk of the Canton Police Station for him. And that Higgins, we learned through the federal investigation, Higgins became angry, demanded that Proctor come back, and he essentially upbraided him and read him the Riot Act, which shows a little bit about Higgins' personality. At the end of the night, everyone discussed going back to 34 Fairview, and when he gets back to 34 Fairview, he texts not Karen, he texts John O'Keefe at 12:20 a.m. He testified before the federal grand jury that he had no knowledge that they had been invited to 34 Fairview, but that is contradicted by this text message. And the inference is that he was coaxing John to come to that house. And we're not saying this gives him a motive to kill John, but we don't have to show that. Any motive to feel hostility or animosity towards John O'Keefe goes to his motive. And Your Honor, when Brian Higgins and Brian Albert are in that house, they're the only two people who are unaccounted for when the rest of the group was in the kitchen. And they claimed that they were looking at photographs together. And we have evidence that they were in the basement. We believe that Brian Albert made a mistake before the state grand jury by testifying they went upstairs to look at photos. Brian Higgins says unequivocally that the only place the two went was into the living room to look at photos and military ribbons, whatever they were looking at. Brian Higgins did not know that Brian Albert had said they went upstairs. And he also testified he had never been upstairs at Brian Albert's house in his life. That means that if Brian Albert said they went upstairs, they're coming up from the basement. And before leaving 34 Fairview, Brian Higgins testified he was parked right in front of the mailbox. He would have had to have walked by where John O'Keefe's body was. His headlights, when he got in his vehicle, would have been illuminating where John O'Keefe's body would have been in the yard if it were actually there. So how does he not see it? He then goes back to the Canton Police Station at 1:30 in the morning after leaving 34 Fairview. He claimed to do some administrative work, but then he admitted to the federal grand jury that he was there to move his car because of the upcoming snowstorm. This suggests that he was fabricating a reason for going back to Canton Police to establish an alibi for himself. He was asked several times at the federal grand jury if he had any conversations with anyone before he went to bed. And when was he notified that John O'Keefe was dead? In the morning, he said. He testified under the pains and penalties of perjury that he had absolutely no contact with any person that night for any reason whatsoever. But he apparently was surprised that the federal authorities had subpoenaed his phone records, and he had to admit, and he did admit under oath, he made that 2:22 a.m. phone call. Around the same time, about 5 minutes before Jennifer McCabe is Googling how long to die in the cold, about 8 minutes before Brian Laughlin, the plow driver, first drives by the house and sees no body at all. And the next morning, Brian Higgins, the first person he spoke to was Brian Albert.
I'm going to stop.
I'd like to get your guys' opinion too on that text. Something that's always bothered me about Karen Reed and Higgins' text messages is how without going too far into it, basically what bothers me more than anything is how she texts him that John's dead and there's no response. And that not only that, the text message itself, all she wrote was John's dead. To me, it just seems weird. Does anybody else think that? I would be like, hey, something bad happened, or I don't know. Does anybody else think that's just a strange way to relay that kind of information? Especially to someone that you would have been flirting with behind his back for the last however long. It's sus. Okay, so it's not just me. Okay. Because I'm like, it just seems an oddly weird way to tell someone that kind of information.
You for a minute. I think we need a break, Madam Court Reporter. Do you need a break? Can you go? How much longer do you think you have with this, Mr. Unetti? How many more pages, or how long you think?
Yeah, I've got about, in terms of my recitation of the facts, I've done about a page and a half, and I've got 3 left.
Yeah.
Court Reporter, would you like to take a little break? It's hot in here. And
Exactly.
you're going nonstop. Okay.
I don't think. I don't know. I don't think now thinking you saying that, I don't think I could have said it in a text either. I think I would have made, if I had to text and I couldn't make a phone call, I would have said, hey, something really, really bad has happened and I need to tell you, or call me, or I can't, talk about it right now, but it's something you really need to know. Maybe you should call so-and-so. I mean, I don't know. I think his text the night before was at the top of her contact list. and he was there, so she was hoping maybe he knew something. Yeah, but even if that was the case, like, wouldn't you, I don't know, even if that was the case, like, wouldn't you say something else besides just a blanket statement that John's dead? Don't think she cared enough about Higgins to break it to him more calmly. Oh, true. Like, yeah, I could see that. But I still think, like, even if I didn't want to, I mean, I know that maybe it's just me, because it's just my opinion, but even if it was someone that I didn't truly care what they thought, I still, for me, wouldn't be able to just say 2 words about someone dying, especially my boyfriend. Like, I can't imagine a single person I could text and just say, so and so's dead. If say my boyfriend died. Yeah. Okay, I get, yeah. John said you. Oh, I get, okay, I get what you're saying that way too. Yeah, I could see that. That would make it makes a little bit, at least thank you for that, Mary B, because think about it in that regard. It definitely makes it a little bit, I mean, it makes a little bit more sense that way than it does like in my head, the way I'm hearing it. And that's the thing with text messages alone, is that inflection and the way you perceive a text is not always the way it's meant, you know? So it's strange all the way around. Let's see, but to be fair, when my ex-husband died, I called people and I was so upset. Yeah. Yeah. I mean, I just called family, yeah. Yeah, see, I agree. I agree. And like I said, even if it was somebody I didn't care about or care about their feelings, like, my feelings wouldn't allow me to just text someone, so and so's dead, and just nothing else. Like, you're seriously trying to hit on me while my boyfriend was there and now he's dead and you suck. Yeah. And like I said, I think you hit that one, right on the head, Mary B, because I can't make sense of it any other way. And with that thought and, putting it that way in mind, I can see how someone would do it that way. And I think that's the only way I could see someone doing it. But see, to me, if I was going to do it that way to someone, to be like a fuck you to someone, I would have said it. I would have been like, John's dead, you asshole. Like that. Yeah. I too, I was the same way. I wasn't thinking that way. That's why I couldn't get over that text. And that's why I asked, because I couldn't understand the lack of anything besides the blanket statement that he's dead.
Let's take a 10-minute break.
All right.
All right, Mr. Yannetti, go right ahead.
Thank you. Your Honor, I left off with the morning of January 29th. The first person that Brian Higgins spoke to was Brian Albert. He had missed a call from Chief Kenneth Berkowitz earlier. Immediately after getting off the phone with Brian Albert, Brian Higgins drives back to 34 Fairview, where he has a meeting with just all the witnesses in this case.
Mary B, that totally makes sense. Because it's funny you said that, because I have a person in my life who's exactly the same way too. Very blunt, to the point. But also the person I'm thinking of would have said it that way, the way like they would have added the fuck you or asshole or something nasty at the end to make their point. You know what I'm saying? So that it wouldn't have been misinterpreted in any way, shape, or form. Like it would have been, they would have made it known that this is a you know, this is a stab at you because you're an asshole or an F you or whatever. Okay. Oh, so you okay, passive aggressive. So yep, see, I get it. I get it now. Thank you, Mary B. I appreciate it because I can truly see how that makes sense, you know, and how that text can make sense the way it was written that way. Because the way I was thinking about it, I couldn't make sense of it. You know, from someone who is, I'm just thinking, like you're relaying to someone that someone they're close to or work with or whatever. Either way, you're relaying to someone that they're gone forever. And how do you just do that in 2 words like that? But now that you put it that way, I can totally see how someone does that. Yep. Thank you.
Julie Albert, Jennifer McCabe, Matthew McCabe. And immediately after that friends and family meeting on his day off, which is a Saturday, he returns to the Canton Police Department where he speaks with all of the first responding officers who had anything to do with this case. So this is a quote unquote witness accessing and communicating with all the first responding officers, we would argue monitoring what they're doing in regard to the investigation. According to Brian Higgins, he admitted that Chief Berkowitz is one of his best friends, and that's why he had access to all these people. We have a law enforcement witness who will testify to seeing Chief Kenneth Berkowitz and Brian Higgins alone with Karen Reed's vehicle on the afternoon of January 29th of 2022 for, quote, a wildly long time.
So is this a name that's been in the materials? Is this a name known to the Commonwealth?
Yes.
Or is this somebody known? Okay.
We've now received video surveillance from the Canton Police Department that shows that there is an interior camera in the Sallyport garage where the car was housed. But during the exact time that third-party officer indicates that Berkowitz and Higgins were in the Sallyport together, the video mysteriously cuts out for 42 minutes between 5:08 and 5:50 p.m. And just to be clear here, we never get to see the condition of the taillight when it's brought into the garage. When we do see the car, we see it after Brian Higgins, Chief Berkowitz, Michael Proctor, and Yuri Butnik have all had access to it. At 5:36 p.m., the car pings that it's arrived in the Sallyport. That's during the missing video. Trooper Proctor, Trooper Butnik never sees Brian Higgins' phone. They speak with him, and he takes it upon himself to use his own resources, Brian Higgins, within the federal government to ask a friend, Special Agent Matt Kelch, to download only the text messages in his phone between Karen and him and John. And that's it. We have to take his word for it that we got all of them. And we certainly don't have any communications between him and Brian Albert, for instance. On February 10th, when he shows up to his interview with Troopers Butnik and Proctor, he brings with him copies of the text that he has deemed relevant in their murder investigation. And he hands them the copies of the extraction that he had his friend do. He then calls Matt Kelch the weekend of this incident to do the limited extraction. He never tells Trooper Butnik or Trooper Proctor how he extracted the tests, despite the fact that it was done by a friend of his in the federal government. During the federal proffer, Brian Higgins admits that he had been served with a preservation order, and the Commonwealth told him he could destroy his phone despite the order. He then drives to a military base on Cape Cod, opens his phone, breaks the SIM card, and throws the phone away. And he says that he discussed destroying his phone with Brian Albert. Brian Albert also destroyed his phone. And Brian Albert said that he had received some text that concerns him as an explanation. And after that, Brian Higgins changes his phone number and changes his cell carrier. In short, he was present that night. He had a motive, and there is plenty of consciousness of guilt cover-up evidence with regard to Mr. Higgins. Moving on to Colin Albert. Shortly before January 29th of 2022, Colin Albert lived with his parents, Christopher Albert and Julie Albert, on John O'Keefe's street, just 2 doors down. We have evidence of bad blood between Colin Albert and John O'Keefe. We have evidence.
How old was Colin Albert at that time?
I believe he was 16 at that time.
Okay.
We have evidence that Colin Albert and John O'Keefe used to get in confrontations because Colin Albert used to cut through his yard without permission, and John O'Keefe was not happy about that. We have evidence that Colin Albert used to throw beer cans intentionally into John O'Keefe's bushes, and John O'Keefe was not happy about that. We have evidence that Christopher and Julie Albert knew of this conflict. We have evidence that they referred to John O'Keefe as Nebercracker. That's a character from I think a kid's movie, who was known as the get off my lawn guy. When John O'Keefe and Karen Reed were vacationing in Aruba over New Year's Eve 2022, the Alberts, Christopher and Julie, taunted him. They went to his porch, And they had photos taken of themselves drinking on John's property when he wasn't there to do anything about it, evidencing they knew how upset he was at what Colin Albert had been doing. Now, the investigators in this case, Your Honor, including Michael Proctor, kept Colin Albert's name completely out of the police report. When this case began, I had no idea who Colin Albert was. I received a tip right from the jump that Brian Albert and his nephew had beaten up John O'Keefe. I didn't even know Brian Albert had a nephew at that time. But after receiving the tip, I learned of the conflict that Colin Albert had with John O'Keefe, so I sent a letter to Mr. Lally, I believe by certified mail. I knew that the DA's office was planning to present evidence or witnesses to a grand jury, and at that early juncture, before anybody had asked them to indict, I notified the DA of 3 potential suspects, the ones that I'm talking about now: Brian Higgins, Brian Albert, and Colin Albert. After he received that letter at our next court appearance, I'm sure Mr. Lally can confirm this, he acknowledged that both Brian Albert and Brian Higgins would be testifying or had testified before the grand jury, but he questioned why I included Colin Albert in my letter. He told me at the time that he had no evidence that Colin Albert was there that night. However, after receiving my letter, lo and behold, multiple witnesses testified that Colin Albert was at 34 Fairview the night of January 28th to 29th. And now the DA will argue, I'm sure, at trial that he left before John O'Keefe arrived. We don't find their evidence compelling. We don't accept it. We are not required to accept their theory of the case. We're entitled to present a defense. His presence at 34 Fairview gave him the opportunity, along with the motive, to harm John O'Keefe. With regard to Brian Albert, Your Honor, this is a well-connected, well-known, powerful family in the town of Canton, Massachusetts. Brian Albert was present at that home when Colin Albert was there. Colin Albert is a member of the Albert family. He's a nephew of Brian Albert. We have evidence that Brian Albert had expressed hostility toward John O'Keefe as well. And we know that he initiated a phone call with Brian Higgins at 2:22 in the morning. He reached out to Brian Higgins. And then he picked up the phone when Brian Higgins came back, and they spoke for 22 seconds. And they never revealed any of that to investigators. Again, consciousness of guilt. And perhaps most of all, Brian Albert is a first responder. He is duty-bound to help somebody who's in trouble. He was notified that John O'Keefe was in trouble. Brian Albert stayed in his home. He knew what was going on outside. His sister-in-law was out there, civilians, medical personnel eventually arrived. He did nothing. That is also consciousness of guilt. Now, Your Honor, with regard to all of that third-party culprit evidence, to admit it substantively, which I would assert to the court is both overwhelming and powerful. With regard to the Bowden argument here, the police investigated none of that. That didn't come from the Commonwealth. They had a complete lack of curiosity as to what was going on in that house that night. They didn't care. Investigators never went in. The feds investigated, and that's where we got a majority of this evidence. So, to the extent that the Commonwealth now claims that they didn't have notice of this, I beg to defer. They got notice of this when we got notice of this. The Finney case, Your Honor, again, I'm well familiar with it. It stood for the proposition that, if you want to point the finger at a third-party culprit, you've got a constitutional right to do that. And if you want to point out inadequacies in a police investigation, you have a constitutional right to do that. And it's for those reasons that I ask you to deny the Commonwealth's motions.
Okay, thank you. Any response, Mr. Lally?
Briefing on it. Just first, again, what the case law requires is evidence and not just mere speculation, or saying that you have evidence is not actually evidence. I do find it somewhat interesting that Mr. Yannetti wrote apparently 4.5 pages of notes, but didn't have time to write a motion to admit the evidence that he claims that he has. He references in regard to third-party culprit, Dr. Sheridan, who indicated that the injuries are consistent with the fight. He's the same doctor who indicated that the injuries on Mr. O'Keefe's arm were consistent with the dog bite, which was then refuted by the DNA findings from UC Davis, as well as the fact that the injuries are only on one side of the arm. And last time I checked, dogs have teeth on the top and the bottom, and there's no injuries to the bottom of Mr. O'Keefe's arm. Furthermore, the counsel references the federal grand jury materials in which I would say.
Oh my God, I have a question for you guys. Okay. So I don't really know. I did know this about the DNA that they looked for. As far as I know, they did look for DNA from the dog. Did they not? They didn't find? Is it that they didn't look for some and didn't find any, or that they didn't look for any? And I'm just hearing about this, that was their argument, that because dogs have teeth on the top and the bottom, but that doesn't, wow, that's the first time I've heard that kind of argument too. But being that, especially in the second trial, because I've seen the second trial, with La Posada, She's the one that testified about the dog biting, that she felt that those were dog bites. They swabbed but got none. They got, oh yeah, the pig DNA. That's right. I forgot about that. That's right. Someone had made a comment just recently about the pig DNA, about why it made sense. And I can't remember what it was. They only swabbed, okay, wait. They only swabbed John's shirt. And they found, okay, so they only swabbed his shirt, not his arm. Oh yeah, dog treats. That's right, because dog treats they eat pig's ears as dog treats. My ex's dog loved those things. Hey, Care Bear. Good to see you. Yeah. Okay, so that makes sense why there would be pig DNA, which, okay, totally makes sense. But I'm still, okay, so I'm confused. Why would they only swab his shirt and not his arm? He was in the hospital, so I wouldn't think they'd get DNA on his arm after being treated. That's true too. I mean, but if they didn't even try to swab his arm, like inside the cuts, to see if those were from, the dog nails, him scratching and biting. Yeah, exactly. Incompetence. See, that's where my mind goes, is that how would you not do that? How can you swab the shirt, but not the actual wounds? Okay, so if you remember correctly, they washed his arm at the hospital while treating him. But still, even if they washed his arm, you could still swab inside the wounds to see if there was any trace. If you're going to bother testing the shirt, you'd think that they'd at least try to test the inside of the wounds. To me, that makes no sense.
As has been done numerous times previously, is severely mischaracterized as to what they actually contain. And it's not a crash reconstruction.
Oh,
as has been
okay,
alleged
wait.
here before. It's a biomechanical.
Okay, so I know they weren't deep wounds, but they could still swab them. And here, so that's why the shirt got swabbed 6 weeks later. Okay, see, I didn't know that either. So thank you. That's why it was so confusing to me. So if they didn't even think about doing any swabs until 6 weeks later, that makes sense of why they didn't do swabs of his arm. But still doesn't make sense that none of them thought to do that from the very beginning. Because in my mind, it's Dr. Laposada, right? I'm right that she was the ER doctor, or former ER doctor, who had treated dog bites and dog wounds. You would think that another ER doctor would similarly have, experience with dog bites and dog scratches and all of that thing, that you would think, like, hey, but would that be on the doctor or the cops to come up with that idea to swab the arm? They never swab, right? That's my point, though. Hi, the virtual juror. Thank you for coming by. So they never swab the arm, but that's what I'm saying is, like, why wouldn't they? She was the former, okay, who was the former ER doctor? See, I always get those two confused. The former ER doctor was, why do I always forget her name? Yeah, and I can't remember her name for the life of me right this minute. But yeah. Okay, so to me, I'm wondering now, since they didn't swab his arm, who would have been responsible for thinking, hey, these look like dog bites or dog scratches where maybe we should swab the arm for DNA? would that be up to the cops to totally up to the cops, or would the ER doctor have said, hey, maybe you want to take a swab of the arm? That's what I wonder. Let's see, they weren't going with a dog theory. They were investigating in a car crash, so the incompetent cops wouldn't look right. See, I guess that's where my problem lies, is because I'm looking at this from the back end, you know, of all the stuff I've seen, then maybe, you know, it's just because of all the info I know that I would think that. But still, in my mind, it still goes back to the fact that the ER doctor has to be somewhat familiar with what dog bites and wounds that are made by dogs, you know, dogs' nails, and that would look like. That one of these doctors that treated him might have said, hey, that's what this looks like to me, or it might be, or something. And I just wonder if it could have ever been mentioned, and the cops were like, well, yeah, no, we're not going to do that. Obviously, they, you know, they'd go out of their way not to do something like that. Oh, yeah. Okay. Dr. Russell. Thank you. I couldn't remember her name for the life of me. Thank you. Thank you. Let's see, but that was the one Hank asked if she had memory problem. Oh, yeah. Oh, that was so awful. Dr. Russell, she was amazing. I loved her. I loved her response. Every time Brennan tried to go at her, her answers were always a fuck you. Like, you know what I mean? They were the perfect way to answer. He could not get under her skin as hard. He was trying so hard to. See, the Emmy too. See, that's another thing too. That's where my mind goes. All these doctors that saw him and saw those wounds, and not one of them said, hey, you should probably swab this. You know, like that confuses me. Yeah, I agree there. But after they realized, you know, that he was beyond saving, you would think that they'd give give some information to the cops and to who, you know, the immediate family, like, look, this is what I think of the wounds that I see. This is what I think of, you know, my opinion. And I wonder, do you guys know if, like, the hospital reports have ever been put out there or talked about anywhere? Because that's what I'd like to see. Yeah. She was amazing. I know the cops don't have to listen. I get that. And that's where they wouldn't have listened if they were told. I get it. I just wonder if they were ever told. You know what I'm saying? Like, I wonder if there's any documentation whatsoever about, being that I work for a surgeon, no less. I wonder what their notes were like when they went to dictate their notes on the treatments that they gave him. If there was ever anything noted in there about those wounds, about the doctor's opinions of those wounds. I know we didn't have the x-rays. They pretended they didn't even have x-rays. And here's me, like, people like me who watched the second trial, and, you know, well, I mean, everybody basically, because the x-rays, right, weren't in the first trial. So duh. So everybody were like thinking there were no x-rays, when all of a sudden, what are you talking about? Yeah, there were x-rays. Like, what the fuck? I don't think they've ever been officially released. Some of Officer John O'Keefe's photos have, and they never should have been. Yeah, I agree. I don't know why people have to look at the photos. It's not necessary. I totally agree there. But the hospital report, like the doctors dictate his dictation, his notes, his dictated notes. That's what I want to say. That's what I'd be interested in seeing. We all freaked out that we went through an entire trial and never saw x-rays. Like they didn't exist. I'm assuming you, yeah, exactly. It's insane. I don't know how all of this stuff happens. And I think what still boggles my mind is how all of these, not only just one or two of these things happened, but so many. I mean, just piles on piles of shit that you wouldn't see in any other trial. And there's not somewhere, some higher authority that could have came in and said, this is a farce. This is, no, we're not doing this. This is not right. There's something wrong here. You know, I mean, I know that they came in and investigated the police department, but still, like, the whole court thing, her being tried the first time, let alone the second time, you'd think there would be some sort of authority that could come in and say, dude, this is all wrong. Like, look at all these things you guys fucked up. This is not, you can't do this. So, I don't know. It's weird. Yeah.
Engineer. And essentially what they did was take painstaking lengths to go to determine that the defendant's vehicle did not strike Mr. O'Keefe in the back of the head, which is simply something that no one has ever said, intimated at any point ever. There is also a medical examiner in the federal materials who concurs completely with Dr. Scorbello's findings as it pertains to the cause and manner of death. So with regard to each of these, the other thing that I would point out is counsel record with the Finney case. The Finney case relates to third-party culprit under the Bowden. So it's not applicable to what counsel was arguing. It is a low standard, but it's also one that the defendant here has not met. It's not one without limits. As it pertains to much of the material that was summarized as far as speculation as to what different things counsel feels mean from various things regarding Mr. Higgins, Colin Albert, and Ryan Albert, just starting with Colin Albert because that's frankly the easiest. He wasn't at the house, and that's what the federal materials confirm. With each of every single witnesses that were spoken to by the district attorney's office or the troopers or testified to the state grand jury, they testified to the exact same things in the federal grand jury. That Colin Albert had left the house prior to the defendant and the victim arriving there, and there's absolutely nothing to combat that whatsoever, other than, again, just rank speculation. So opportunity would be a little bit amiss if he's not even there at the same time as Mr. O'Keefe, regardless of the invalidity of any sort of ill feelings or ongoing feud that's reported from whatever unknown evidence counsel claims to have. In regard to Mr. Higgins, that was a fanciful story, but again, there's actually no actual evidence of most of those things, or at least the imputations or the connotations the counsel wants to put behind that. Whatever he feels things were observed. So again, I'm not sure where the evidence from this is coming from. What I'm also a little confused in regard to is that if counsel is merely relying on materials within the federal grand jury and just learned of them at that same time as we learned of them when materials were provided pursuant to TUI, then it's a little peculiar that the exact same arguments were being made throughout the pendency of the case well before counsel was provided with any of those federal materials. What counsel just went through is essentially a list of rank speculation and not actual evidence. As far as the mysterious portion that's missing from the Sally port, there's a number of different, it's a motion activated camera for the most part. The other thing that I would direct the court's attention to, as it was contained within the state grand jury proceedings, is there is cruiser camera video from the Canton Police cruisers. Specifically, there is cruiser camera video from cruiser 682. Specifically, there is cruiser camera video from cruiser 682 at 8:22 in the morning when a lieutenant and sergeant from the Canton Police on their own go over to One Meadows Ave, which is the residence of Mr. O'Keefe, to do a well-being check because they had not received any information as to how the children were or if they were there being attended to. And they pull into the driveway at 8:22 in the morning, directly behind the defendant's vehicle, which is exactly where Ms. McCabe parked it when they stopped there to see if Mr. O'Keefe was there before then piling into Ms. Roberts' vehicle and proceeding to 34 Fairview. And what you can see within that cruiser camera video at 8:22 in the morning is the damage to the right rear taillight of the defendant's vehicle. Well before the defendant had then come back to the house after the hospital and then gotten in 3 separate cars with her family and driven in a blizzard all the way back to her parents' house in Dighton. And then the vehicle had then been towed from Dighton back to the Canton Police Station by the state police with the assistance of the Dighton police.
Do you know what exhibit number that is before the grand jury?
I believe it's 56, but I can certainly locate that information. And again, as far as Brian Albert is concerned, I heard nothing other than he's apparently in a well-connected family in Canton, and Colin is his nephew who wasn't present at the house when Mr. O'Keefe and Ms. Reed were present at the house. So again, I think it's a stronger argument, certainly, if
I totally did hear that. I just didn't want to stop it and annoy you guys in case it's too much stopping. But yeah, I don't know what the hell you mean mostly. I mean, obviously, there were glitches, if you want to call it that. But, and I'm sure you guys see, why am I blanking on everybody's name today? Oh my God. I'm sleep deprived. I was up too late watching Kazi last night. Microdots. I mean, microdots, those videos are amazing. But looking at those, when the apparitions just appear, these people just appear, and their excuse is, oh, it's motion activated. So motion activation means the minute it spots motion, that's when it starts recording. Somebody isn't going to be walking through the garage and then it just picks it up when it's like it's already they've already been sweeping or cleaning or whatever they were doing, and then, oh, I guess we'll start now, even though I've detected motion for several minutes. What? Are you serious? Richie, yes. I don't know who Richie is. I have heard that. I know that somebody outed him. I'm assuming it was one of the fucktards who outed him as Microdots. I did hear about that. But whoever Richie is, you are amazing. I love your videos. I await more. Yes, Richie equals Microdots. I just don't know who Richie is by that name. Like, I wouldn't know if I saw a picture of him. I wouldn't know who he is, unfortunately. I just have heard his name. Algido, gotcha. I got it. Of course she did. I'm not going
strap
there.
onto a Bowden defense, and counsel will probably likely be allowed to at least investigate that as far as impeachment, cross-examination, things of that nature. But there is absolutely nothing beyond just a fertile imagination and rank speculation as it applies to a third-party culprit defense. And for that reason, Calmo's motion to exclude it should be allowed.
The only thing I'd like to correct, Your Honor, is, well, or at least point out, is that, the car pinged at 5:30.
So hold on until you get to the microphone.
Yeah, I'm sorry. The car pinged at 5:36 p.m.
The
indicating that it
virtual
was in the
juror,
report.
because you
There
weren't
is
here
no
earlier, I have a question for you, Maitland, too. I had to play it a couple times. I don't want to go back to it now because it would take me forever to find it again. But did either of you see there is a motion, a pretrial motion that I was playing earlier, where somebody, Mary B had heard it too before, but she had forgotten about it, she said. So I'm wondering if either of you two had saw. Oh, don't worry, Maylin. I appreciate you coming. I really do. No matter what time you guys come and go, I truly appreciate it. I want to watch this trial no matter what, so this just makes it a little bit more fun. But apparently in one of the very first pretrial motions of the first trial, someone hijacked the Zoom and started saying free, now I can't even, free something Tibbets or free somebody. And they thought they had kicked him out or taken care of him. And Alan Jackson starts, going through his motion again, and all you hear is, fuck you, Beverly. And I wasn't expecting that. Billy Tibbet. Okay, yes, Billy Tibbet. Thank you. Okay, so did you see this hearing or hear about it or see it clipped anywhere where he does, like, it was right in the middle of his motion, or it was right in the beginning of Alan Jackson's motion, a Zoom hearing, and he's like, free Billy. And then he said the last name. I think he said free Tib, and he said Tib something about it. And then they thought they had gotten rid of him. And he comes, all you hear is, fuck you, Beverly. And it was just hilarious. I'm like, this guy called this judge out way before the first trial even started. I don't know the story. I need to find out who he is. That's on my list of rabbit holes I'm going down. Obviously people think he's in jail. I'm assuming he's still in jail then for something he didn't do. And I can only assume that this piece of shit judge is the one that He's an ex-hockey player. Okay, that even intrigues me even more, because I love hockey. Free my boy Billy Tibbetts. LOL. That Zoom was hilarious. Yeah, I was not expecting that. It just happened to be the first motion I started playing. When you get a chance, scroll back to the beginning, close to the beginning of my live today, where I start that, and I just I didn't bust out laughing first. I had to stop it and go, wait a minute. Did I just hear what I think I heard? So I played it again, and I was like, I couldn't help but bust out laughing. I'm like, way to call out this judge way before any of us knew who she was. Well, people that didn't know, obviously, this Billy Tibbetts. It's insane. But it cracked me up.
Camera where you can see the car about to enter the Sally Port at 5:31. Of course, you can't see the tail light in that outdoor, camera. But Mr. Lally just argued before you, well, the reason why there's no, video of the car between 5:08 and 5:50 is that it's motion activated. And I just asked the court to use common sense here that if the car's entering, and by the way, the car's there at 5:50 with a couple of people around it. When the camera comes back on, you see the car. So unless it was teleported in a split second so that the interior camera would not pick up motion, it drove into the Sally Port. I believe that's the definition of motion, and it should have been picked up according to Mr. Lally's own words.
Okay, so when you walk away from the microphone, it's harder for the court reporter to hear you, Mr. Yannetti.
And I apologize, Judge. It's according to Mr. Lalley's own words, it should have picked up the movement.
Okay. All right, so I believe that's the last motion. So why don't we recess until 2 o'clock? And I'll see you back here at 2. Mr. Lally, will you have Ms. Gilman, who I did see walk in here at one point, set up the screen right where we normally keep it?
Yes, sir.
Thank you.
All right.
All right, Jim, I need just a minute of the computer, please. Okay, thank you.
Back on the record on the Karen Reed matter.
Okay, so good afternoon, counsel. Good afternoon, Ms. Gilman. I appreciate you being here. Before we see this video, just briefly, I just want to say that there were really only two
I got
motions
something
that I'm
right
comfortable
now.
with.
Miss Gilman is the court reporter, correct? You guys know? Because if Miss Gilman is the court reporter, she literally screamed at Alan Jackson for addressing her as anything but Madam Court Reporter. And she said in her 30-some years or whatever that she worked with her, that she's never called her anything but Madam Court Reporter, and she just called her Miss Gilman. If I'm wrong about that, I'm wrong about that. But that's how I remember it. Nancy. Yeah, okay, that's right. I do know her first name. But I'm pretty sure that's her, though. Her last name, Gilman. I think Miss Gilman, that's her name. And I'm pretty sure that Judge Canoni, when she's yelling at Alan Jackson for calling her Nancy, she had said, she's worked for me. Yeah, Alan called her Nancy. So, but when she went off on him for calling her Nancy, she said she's worked for me for 30 whatever years. I've never called her anything is the media person. Okay, so I'm wrong then. If that's true, then I'm okay. I get it. If Miss Gilman is not Nancy, then what I'm saying it doesn't matter. But I just thought that was funny because she's like, I've never called her in my 30 whatever years. I've never called her anything but Madam Court Reporter. So I don't know. See, I'm gonna have to look it up. So I'm gonna continue this because this motion's over in a couple minutes. So
deciding.
Finish this one. I'm gonna look it up while we finish
Call
this.
here. Commonwealth's motion to eliminate of intent to obtain Corey. I don't know if I already allowed that, but that's allowed. And the Commonwealth's motion to eliminate, Jim, I think this is 317. Commonwealth's motion to eliminate to prohibit reference to any federal investigations conducted by the U.S. Attorney's Office or FBI. So that will come into evidence the way that it typically does here in Massachusetts. You can question as to a date where the statement was made under oath, and we can discuss it as it gets closer in more detail. So the other motions are under advisement. We'll talk about that when we come back to sort of housekeeping matters at the end of the day. So do you have that video all pulled up, Mr. Lally, for me to see?
Yes, Your Honor.
Okay.
And Your Honor, for the record, it's a little bit lengthy as far as the entirety of the video. The portion that I would be submitting to the court is from 7 minutes and 4 seconds until 9 minutes and 55 seconds.
Okay. Can we, thank you.
So we got the house, I told you just did the non-fluff.
Okay, can you explain to me what the process is right now?
Absolutely. So you're gonna be the fluff just like last time. Go through the same process, it's gonna be a little less time consuming, because we're not gonna do major case prints as we did those last time. Once you're booked and you go through this portion of it, we'll let you make a phone call just like last time.
Thank
You'll make a
you,
phone
Fresh
call,
Brown
your
Eyes.
parents will be able to bring you whatever other additional needs, things that you need.
Yeah.
And then tomorrow morning, you'll go and be arraigned at Norfolk Superior Court on the charges that were, I'm sure you'll go over the charges again, we'll be on more.
But I'm on bail, so how can I be spending the night here again?
All right, so I'll explain that portion to you, as long as it's not going to interfere with you. Are you ready to go? Yeah, I'm just waiting for
Yeah.
Okay, so,
Okay, so yep, you went back and free Billy Tibbetts in the trap. That's what he said. Yep. Fuck off, Beverly. Yep. It was freaking hilarious. Have a good dinner, hippie chick, if you're still here. See you later. So the court reporter, okay, is Nancy King. So what I just said, it doesn't matter. However, you're absolutely right. I didn't even think about that too. Right here. Yes. Because reading the sidebars and going through the videos of sidebars, she does call her Nancy at the sidebar. After, yeah. But not only after that, she's done it. She did it before too. And if I remember correctly, and she literally ripped AJ a new one and said, in my 30 so-and-so years, I've never addressed her as anything but Madam Court Reporter. Which was a fucking lie, obviously. Hey, Fearless Farm Girl, how are you? I'm glad you came. Yes, I didn't watch the Aaron Hernandez trial, but I did watch the documentary on him. It was heartbreaking. Oh, I went and pee. I thought it said I went to pee, but I got it. Yep. Yep. She did. And then, and has the nerve to scream at Alan Jackson for calling her Nancy. And then not only yelling at him for calling her that, she literally states that she's never called her that, which is bullshit. Sarah, hi. I saw your comment earlier, but I didn't say hi. So hi, thank you so much for coming. I'm so excited to see you guys here. Thank you.
initially, your arrest was on probable cause out of the district court, okay? So the charges you were arrested on initially were out of district court, still in district, that's where the arraignment was, those district level charges. Today, grand jury indicted you on these
Okay,
charges.
so Connor, what with whatever happened to Billy Tibbetts, is that what it is that happened down the street from you? Or what happened with Karen Reed? Yes, she does. Yeah, I'm gonna stop streaming probably after this motion because I want to go watch the Red House Media, their pre-game show for the Turtle Boy. No, Hernandez. Oh, okay, gotcha. Duh. Gotcha. Yeah, it was really really sad, his story, and especially with the letter he wrote, and then supposedly taking his life in jail, and that it was heartbreaking. I got 40 minutes. Thank you. It means that maybe we can go through one more motion after this one, because this one's over in just a couple minutes. Yeah, I was when that Hernandez stuff came out, I was a huge I still am, but just not as much because they suck, but a huge Pittsburgh Steeler fan. I have been for 25 years, a huge Pittsburgh Steeler fan. And him playing for, a rival team, it was a big thing. And I don't know, I know most of my friends that are in here with me are women, but Connor, do you watch football? Like, I know I could have this conversation with Turtle Boy if he was in my chat. But back when the Steelers were good in that, and oh my God, hold on one second. Sorry, someone's buzzing my phone. All right, sorry guys. You do watch? Oh, you watch football? Okay, awesome. I love football. I normally can't talk football with other females. They look at me like I'm crazy. But I'm taking a break from fighting with AI. Oh, I am scared of AI. I tried using it a tiny bit, trying to make videos and stuff, and it scares me to death. I don't know if I will start getting used to it or not. Time will tell. But yeah. Oh boy. But anyway, if you watch football, if you're familiar with the Steelers at all back then, had some great players back then, especially when Big Ben came on the scene, and we had Hines Ward, and we had a couple that went crazy, and yeah, I could go into that, but that's another day, another stream, whatever. The bus, yes, see, my people. Oh my God. Oh my God. You're awesome. It's so funny. It's been so long since I really talked to anyone about the Steelers, and even thinking about Jerome Bettis is like, it brings back such fond memories. Thank you for saying that. He was awesome. Awesome. I have to say this before I start. I miss Bill Cowher a lot. Mike Tomlin was not my favorite coach. Let's just put it that way. Oh, you did fantasy leagues too? Yeah. I did too for a long time. I used to do football squares and everything. The older I get, the less I do. I have to. The Bears yep. I remember Hernandez because I'm a New York Giants fan. We played them, and I always hated him playing against us. Yeah. Yep.
Murder, vehicular homicide, and leaving the scene of death. Okay, so those are the charges the grand jury indicted you on. So now you're being charged and will be arraigned in Superior Court, Norfolk County Superior Court in death. Okay.
So bail doesn't apply anymore?
Typically, I'm not. So we don't set bail, but typically, once murder comes into play, people don't get bail.
So it's not manslaughter anymore. What's the difference?
That's correct. It's a higher degree of taking a life. Okay, so that's the charges you're being charged with now, and you were indicted by grand jury.
Okay, you're aware he was beaten up by Brian from Colin Albert. I mean, we're all in on the same joke, right? My taillight was cracked and John was pulverized.
Okay, you need to abide by the rights that were afforded to you. Okay? So you can talk if you want. If you want to tell us what happened, that's fine. We'll listen, but you were ready to do your rights, okay? And then I'm sure he's gonna do it again. All right. If you want to talk to us, you want to give us a story, definitely. But we'll take
I
it.
don't, I mean, I know you already know the story, so what you said.
All right. How long is the entire tape?
So that is Trooper Pye, who was the arresting officer from the barracks. So it goes, I believe, at least 90 minutes or so.
All right. Do you have the entire, we're not playing it now, but do you have the entire video? All right. I would like it marked for identification. I'd also like a copy of it so I can view the whole entire thing, put it all in context. I never like to see just sections. Can I get that for the weekend as well?
Oh, absolutely. And for the record, as far as I think a lot of that sort of preliminary stuff was more meant as context for the court. You know, there's certain discussions about court procedure and things that I don't think should be put in front of the jury.
All right. So that was my concern as well. Okay. So it's something I'll watch a few times and the whole thing as well. Okay. All right. Thank you.
Thank you, Aaron.
Thank you very much.
Thank you.
All right. Okay, so housekeeping matters. A few things that I still need, as you know, before we have the jury here on Tuesday. I need a statement of the case. I know you have a short statement of the case in your proposed supplemental questionnaire. I think it needs to be more than that. So before you leave today, I'd like you all to agree on a joint statement of the case. I need witness lists. If the witnesses are going to be called, I have to read their names, as you know, to the jury on Tuesday morning. Once we get a jury, and I know none of us knows how long that might take, how long will it take to put in the Commonwealth's case? You can tell me with DNA and without DNA.
So with that piece of DNA, I don't think that's going to add much more than an hour or two at the most. But best guess, given the schedule as outlined previously by the court, I'd say probably at least 4 weeks. My hope is there are some witnesses on the Commonwealth's witness list who are essentially testifying just in regard to administrative things, as far as work in an establishment. This is a true and accurate copy of surveillance video from said establishment.
Have you had preliminary discussions about whether there would be stipulations to authenticity like that?
No, but I plan to before Tuesday.
Okay, and you'll do that, Ms. Gianetti? You'll have these conversations before Tuesday?
I'm completely open to that.
Okay. So with the Commonwealth's case going 4 weeks, how long does the defense think their case will go?
With the schedule that the court has outlined, we're estimating about 2 weeks, Judge.
Okay. All right. I need to tell the jurors how long it will take. So if you say 6 weeks, I'm going to tell them 7, which will make it longer for us to get a jury. But
I understood. And then there's also the X factor of how long it takes to get a jury. Right?
Oh, exactly. No, I'm going to tell them once we get a jury, it will be 7 weeks, give or take.
And just while we're on this subject, Your Honor, does the court have any idea in terms of the availability of jurors every day of the week?
We don't have jurors on Fridays.
No jurors on Fridays.
No, and it gets progressively lower as the week goes on. But we've got jurors. Once we start, the trial that is impaneling has priority over all other trials. So once we start, and I expect that we'll start on Tuesday, we'll do that. So there's a couple of things about the voir dire of the jurors. So we will do the voir dire, the individual voir dire of jurors over here at sidebar. And only one lawyer from each side is permitted to ask the questions of the jurors. I think I'd probably be able to give you 5 minutes or so for each witness, no more. And I'd like to talk to you all at sidebar now about your joint proposal of the questionnaire. This is something that is not public. It won't be made public until after it's decided upon and after it is presented to the jurors and they've filled it out. So a blank copy will be available then pursuant to what the law is. So why don't I see counsel at sidebar? Excuse me? Yes, thank you. All right, so is that everything regarding housekeeping, logistics, things like that?
Yes, Your Honor.
Okay, all right, so we'll see you on Tuesday morning. Just so we're clear, there's nothing else logistically or jury impanelment, right? We're good?
I believe so, Your Honor, yes.
Okay, thank you very much. All right, thank you. So we'll see everybody Tuesday morning.
All right, so that one was done. Oh, let me see. What? As someone that has drainage issues, he needs to find the mute button. That said, I also won't get onto him about it being sinus issues suck. Yeah. No, but there's a difference between, having to do that now and then, but the constant, like, did you watch what's his name? Brendan Banfield? Did you watch his trial? The virtual juror? That defense attorney was sniffing his nose every 2 seconds. Oh my God, it was disgusting. It was like, dude, Someone give this man a fucking Kleenex. Yes, and that one was so much a yes. Like, ugh. I understand if you're sick and you have sinuses, things happen, but, politely blow your nose. And if you're going to be stuck in front of court, in court for a while, take something that will, help with that issue. Yeah. Ugh. That defense attorney, oh my God. I literally had to leave Baker's Stream because I could not listen to the sniffing anymore. It was so disgusting. Hi, Cup-You. Welcome back. They also can't call in sick, right? But take some damn meds. Thank you. Exactly. You can take stuff that will curb the drainage for a little while. And then if you need some more, you bring another dose and put it in your bucket, right? Like, wow. So I have until 6 until Rat House Media goes on. So let me see if I can play one more. Listen, I don't know if the next one's short or not. Bear with me a moment.
To properly assess the true facts, which is what we're trying to get to. The true facts. Why is the Commonwealth so intent on hiding the truth from this jury? I'll submit.
Okay.
So let me
I'll
just
likely run that
watch.
today. So, number 28, Mr. Lally.
Yeah. Okay.
Thank you, Your Honor. So, again, similar to the
We just watch it.
Numbers 1 through 66.
is hair. That was confirmed by the Bodie testing prior to conducting any sort of mitochondrial testing. The mitochondrial
Now, the defendant has stood here, defense counsel has stood in this court repeatedly, stood here and in other venues and in their pleadings, espousing various third-party culprit theories or scenarios. But now that it's time to actually try the case in the courtroom, I don't have a motion from the defense to admit third-party culprit testimony. So, and as you're well aware, I have to make findings before any mention of any third-party culprit evidence or even an opening goes before the jurors. In order to admit it, and given that I have no information at all, I mean, I don't know who the third-party culprit is, even after reading 4,500 pages of discovery. I don't know what motive a third-party culprit might have. I don't know how it's relevant. I don't know if it's remote or if it's current. I don't know if it's speculative or if it's relevant. I don't know if it will prejudice or confuse the jury. And if it's hearsay, I have a whole other series of factors I have to consider. So, Mr. Yannetti, are you pursuing a third-party culprit defense?
We are, Your Honor, and I'm prepared to address that. The Commonwealth has raised the issue, and I am prepared to address that today.
So you filed your motions first, and you did not raise it. So if the Commonwealth had not raised it, you did not move to introduce it, correct? I have no motion from.
No, I understand. I understand, Your Honor. If you'd like something in writing for us, we can do that. I have a full argument prepared.
All right, so who is the third-party culprit?
We are under no obligation to name any specific third-party culprit.
How am I supposed? So you're prepared to argue all this?
I'm prepared to argue it, Judge.
All right, so we will get to that when we get to the Commonwealth's motion.
That's fine.
Now, the second thing I want to address, because again, it's very important at this point, the motion regarding the DNA, regarding excluding the DNA. Mr. Lally, why should I not allow that motion?
For a couple of reasons, Your Honor. Number one, what I can provide to the court by way of update is that Most of the testing with regard to that item is complete. So first and foremost, the item is hair. That was confirmed by the Bodie testing prior to conducting any sort of mitochondrial testing. The mitochondrial profile, the partial profile that was generated in regard to the hair sample is complete. The mitochondrial DNA profile in regard to Mr. O'Keefe's sample is complete. The preliminary analysis that I received by way of email from Bodie yesterday indicated that they were consistent with each other. I asked for some sort of preliminary report or something that I could share with council based on their lab's accreditation. That does not permit them to release anything by way of a report prior to it going through a full review process. My understanding is that not only that process, but the entire lab file should be produced by Tuesday. On top of that, what I would state as far as any sort of prejudice the defendant appears that they've suffered as a result of that, there is still zero reciprocal discovery that I've received in regard to anything from counsel. And then part of the delay, at least a portion of the delay in this specific testing, as the court is aware, as you've had a chance to review Bodie Technologies' observance policy as far as outside experts, there was a significant delay in hearing from counsel for the defendant in regard to whether or not they wish to have someone present prior.
How long a delay?
I believe it was at least several weeks, if not a month. We spoke about it in person in December, and I don't believe that.
My order was in November.
Correct. So when we received your order was in November. What took a little time on our part was to get the samples taken from the troopers in regard to the other testing, and in order to get all of those items shipped and transported from the MSPCL to Lorton, Virginia to Bodie.
When was that done?
Late November.
Go ahead.
And then there was a evidence viewing, which both counsel attended. We spoke about it there. I think that was December 1st, and then waited a few weeks, never heard back, followed up on it, and eventually heard back with regard to them not wishing to have anybody present for that.
When was that?
I don't have a specific date offhand, but
I need you to find it.
I can.
All right. So I didn't know that the defendant decided not to have somebody there.
Right.
And that prolonged it. They weren't able to go forward, right?
Yes.
How long will it take you to find that information?
Shouldn't take too long. I would need to check my email.
All right. I'm going to take a 5-minute recess.
Thank you.
You are muted.
Yeah.
Hear from the defense on this, and then I'll give you an opportunity to address it, Mr. Lally. All right.
Thank you, Your Honor. I'd first like to address the timeline that Mr. Lally has just explained to the court. First of all, we were not made aware that we were allowed to test based on Bodie's protocols and procedures until December 1st. We were given a letter saying it would cost $21,000 for our expert to sit in on that testing. We reviewed that letter. We told Mr. Lally that it was most likely we were not going to have someone independently watch the testing because of the price.
When was that?
December 1st.
When? December 1st?
December 1st.
Okay.
We confirmed that in writing when he emailed us again on December 22nd. And I would note for the court that Bodie did not receive the hair from the Commonwealth until January 11th.
Okay.
So there was no delay on our part. As the court knows, to date, we have received no reports from the Commonwealth regarding Bodie Technologies' analysis of the DNA. The Commonwealth has engaged in repeated and inexcusable delays regarding the testing of this particular item of evidence, which at this point is sanctionable. The hair has been in law enforcement custody for more than 2 years, Your Honor. On February 1st, 2022, Massachusetts State Police criminalist Maureen Hartnett purportedly recovered the hair from the bumper of Ms. Reed's vehicle. For a full year, the Commonwealth did nothing. Finally, on March 6, 2023, criminalist Maureen Hartnett got around for the first time.
Sorry, criminalist department? Is that what you said?
Criminalist Maureen Hartnett
Okay, yes.
got around to conducting a visual inspection of that hair for the very first time. On March 6, 2023, she opined that it appeared to be human. However, subsequent discovery produced by the Commonwealth revealed that she had failed her proficiency test in that precise subject matter only 1 month prior. Then, on August 25th, 2023, the Commonwealth submitted that hair to the Massachusetts State Police lab for DNA testing, and it was forensically determined that no human DNA was detected. Almost 6 months later, the Commonwealth made their third attempt to find evidence establishing that the hair was somehow probative in this case. It is now 4 days before trial, and we were told we're going to receive this on the day trial is set to begin. Pursuant to Massachusetts Rule of Criminal Procedure 14C, subdivisions 1 and 2, the court has the discretion to exclude evidence based on the Commonwealth's failure to comply with its discovery obligations. There's no excuse for a 2-year delay. We immediately conferred with counsel when he notified us as to what the requirements were going to be if we decided to have an expert present for testing. We got back to him the day that he emailed us following up about that, and they didn't even bother sending the hair to the lab until weeks later. So I don't think it's fair to blame the defense for a 2-year delay in this regard. As the court may know from the notices of discovery, we've received an overwhelming amount of evidence. This week, last week, the week before that, we're on the eve of trial. It is not fair to throw at us yet another item of evidence that we have to retain an expert to assess. We have to review, we have to make tactical decisions. That's not a fair position to put the defense in. We've been asking for a continuance. I think the only fair thing if the court is going to force us to go to trial is to exclude this evidence.
Okay, thank you very much.
Thank you, Your Honor.
Mr. Lally?
Yes, Your Honor. Again, not faulting counsel for any sort of 2-year delay period, but there was a period of time, given sort of the close nature of when the Commonwealth is receiving this information, that a couple weeks, or a few weeks in this case, do matter. The other point I would make as far as, again, as far as the defendant being prejudiced, this isn't evidence that I anticipate introducing in the first day, the first week, or probably not even the first month of trial. So whatever time counsel needs in order to retain an expert, run that by an expert, run that by one of their experts they already have, I don't know that, whether or not they have any experts, because again, I don't have anything from them. So as far as ample time, I would submit that there's more than sufficient time once the report is received for counsel to make use of it in whichever way they deem appropriate. And for that reason, and I'm certainly not asking the court to continue the trial date, but for that reason, I would ask that the motion to exclude be denied, absent any prejudice to the defendant.
All right, so I'm going to take this under advisement. And I may as well tell you that the best way, I think, for us to proceed with the rest of these motions is, because they were filed so late, which I understand they were filed, just to be clear, I know they were filed by the deadlines, but so close to trial, I don't have written oppositions really, unless you both raised independently the same issue. So what I will do this morning is, my intention is to hear from counsel, to hear at least from the other side, if the motion itself is clear enough, but to hear from counsel. Then we'll take a break, and at 2:00, we'll come back, and anything I can decide, because I know you're preparing this weekend to go to trial on Tuesday, anything I can decide by this afternoon, I will. Anything that I cannot, I will let you know. And then we'll do housekeeping, which I can, including, though it's certainly a very important part of the case, jury voir dire in that. So that will come at the end of, that will come this afternoon. So starting with the view.
Your Honor, I was just going to notify the court, to your discretion, there are a number of motions that will be unopposed. I don't know.
All right, so what I'm going to do with that is, the Commonwealth filed a very helpful list of what their numbers. We have, of course, the paper number, the docketed number. So when I get to that, we'll just go through those quickly. All right, I appreciate that. So you, well, I'm probably starting with one. You could have saved yourselves time in writing the motion regarding the view, because you both want a view. I will conduct a view. You need to talk because you have different locations.
Yeah, and we've, upon consideration, Your Honor, the Commonwealth has asked for a view of 34 Fairview Road. We would be satisfied with a view.
So you don't need to go to the waterfall?
I think that we can just agree to go to that one location.
All right, so you all figure out the view. I am going to take under advisement your request of the defendant coming with us. You know that there are all sorts of things I have to consider before deciding that.
Thank you.
So that part is under advisement. Before the end of today, figure out exactly what you want to do with the view. Mr. Lally, your office will provide state police escort for that view?
Yes, Your Honor.
Okay. All right. Now, court officers, Chief Rose usually gets the bus. So, all right. So for that, so the defendant's motion, it's our paper 283. Defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. So I'll hear whoever's arguing that for the Commonwealth. The Aruba incident, if you will. I mean, I'm sorry, who's arguing for the defense? That's what I'll hear from.
I am, Your Honor.
Okay.
Thank you.
You said 282.
283.
282.
Oh, this is all backwards. Pauline did this for me. All right, thank you.
Thank you, Your Honor. The Commonwealth seeks to admit irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence against Ms. Reed by admitting inflammatory evidence of an event that purportedly transpired in Aruba on December 31st, 2021. As the court knows, this type of propensity evidence is extraordinarily prejudicial and serves no purpose other than to assassinate Ms. Reed's character in the eyes of the jury. The Commonwealth has put forth no reliable evidence to suggest that the incident that occurred in Aruba on New Year's Eve has anything whatsoever to do with O'Keefe's death, or that this remote and isolated incident was even a point of contention in their relationship at the time in question. And we aren't left guessing, Your Honor. All of the witnesses who were present at the Waterfall Bar and Grill on January 29th, 2022, along with high-quality video surveillance footage from that night, established that Ms. Reed and Mr. O'Keefe were happy, they were in good spirits, they were getting along. There is no evidence to suggest that this incident had anything to do with the facts at issue in this case. The Commonwealth points to purported angry voicemails left on the decedent's voicemail to suggest that there was some sort of hostile relationship between Ms. Reed and Mr. O'Keefe that night. However, these voicemails were left after Ms. Reed dropped O'Keefe off at Brian Albert's residence. and after he failed to come back outside to meet her. There is no logical relationship between the prior bad acts evidence in this case, the Commonwealth seeks to admit, and the crime charged here. And therefore, this evidence must be excluded.
Okay, come on.
Yes, Your Honor. So this also relates to Commonwealth's motion to eliminate number 20. So in regard to that, Your Honor, this is highly relevant evidence as it pertains to motive and as it pertains to the nature of the relationship between Mr. O'Keefe and Ms. Reed, which goes to motive, it goes to absence of accident, goes to motive, absence of mistake. And this is not a, as the defendant seems to continuously try to pose it as some sort of temporary or isolated incident. This isn't just the argument or the yelling of swears between the defendant and Ms. Sullivan in the lobby in Aruba. This then leads to an argument which both children indicate in their statements continued inside the room in front of them for about 20 minutes after it happened. This is also not a fleeting reference in the sense that the defendant continuously brings it up on her own, specifically in text communications with Mr. Higgins when she's talking about the nature of their relationship. And it's not just the voicemails that the defendant leaves on Mr. O'Keefe's phone after the murder occurs in front of 34 Fairview. It's also text messages exchanged between the two of them in the days leading up to that, in which they discuss the nature of their relationship. You also have statements from the children which indicate that the victim had tried to break up with the defendant multiple times in front of them, asked her to leave the home and she refused. You also have a text communication from Mr. O'Keefe to Ms. Reed in which he indicates that he thinks that their relationship is essentially—
What was the date of that one?
I believe that was the 28th. Then there's other text messages from the defendant to Mr. O'Keefe referring to their relationship between themselves and with children as toxic. These are further statements regarding infidelity, which continue on to the morning of, in which statements that she makes in the backseat of the vehicle with Ms. McCabe and Ms. Roberts as they're looking for Mr. O'Keefe just prior to locating his body on the front lawn of 34 Fairview. These are statements regarding her belief in Mr. O'Keefe's infidelity that she repeats again when she's having her recorded interview with Ms. Voss from Boston Magazine. These are not isolated statements. These are not just one time 4 weeks prior. It's not too remote in time, and it does show sort of the nature of the relationship and as it's evolving over the course of that month from the date of the incident in Aruba all the way through until the date that Mr. O'Keefe is killed. In furtherance of that, also, there were statements that the defendant makes to paramedics when she's being treated on scene that the last time that she saw Mr. O'Keefe, they got into a fight or an argument, and she's upset because that's the last time that they spoke was during the course of a fight or an argument in front of the house on Fairview Road. So it literally continues from the Aruba incident all the way through to the murder's occurrence. So for those reasons, the Commonwealth would submit that it is relevant as to motive, it is relevant as to absence of accident, and it is relevant as to absence of mistake. Thank you.
All right. What I will need is exactly what the Commonwealth intends to introduce. I think you've outlined it and I'm familiar with it. If I admit it, it would certainly be accompanied by very strong curative instructions, which you know is my right. I've heard argument now. I'm going to think about this and maybe decide it by this afternoon, but.
Thank you.
Okay. All right, so you were both in agreement on what's the defendant's motion to exclude irrelevant and prejudicial evidence regarding alleged harassment and or intimidation of a witness, and the Commonwealth's for different grounds and different scope, actually. Motion to exclude mention of Aiden Kearney, aka Turtle Boy, and his pending criminal charges for witness intimidation. So though you both agree it's out, that doesn't necessarily mean that I agree with you that it should be out. I understand that the nature of the harassment, mindful of the grand jury minutes that I've read that in response to some of the questions posed by those at the U.S. Attorney's Office, the answers explained away some conduct as a result of the extraordinary harassment witnesses were undergoing. So I'm not sure I agree with you. So go ahead and try and persuade me, but what I'm inclined to do is keep it out in the case in chief, but Commonwealth said you told your witnesses not to discuss it. So I'll hear the defendant.
I guess I would start, Your Honor, by saying that in order for evidence to come in, it has to be elicited by a party. It has to be offered by a party. You're being told that the Commonwealth does not intend to elicit this evidence and that the defense does not intend to elicit this evidence. So I guess the question that I would direct to the court is, do you intend to follow up with questions?
I'm not questioning the jury. It's clear that it may be a response, a natural response by a witness that neither one of you intended to get as a reason for something, that I'm not going to sanction the witness because I allowed the Commonwealth's motion.
Sure. So
Mr. Yannetti, yes. So it's clearly you try your case the way you want to try your case, and the Commonwealth decides how they want to do it. But I am not tying the hands of witnesses to natural responses to questions. So I'm taking this under advisement. If you open the door, it comes in.
Well, I completely understand that, Your Honor. I will say that I think probably, I don't want to speak for Mr. Lally, but
So don't speak for Mr. Lally.
I'll speak for myself then, if the court will allow me, which is that if a witness opens the door to further explanation of this, that could give rise to both sides exploring that, which, I suppose we'll deal with that when it comes to it.
The way the motion's written, it would be prohibited, and witnesses, I'm not tying the hands of witnesses to natural answers that are the result of questions asked by counsel.
Right, understood.
Okay, do you understand that, Mr. Lally?
Well, absolutely, Your Honor. And that was not my intent. If
How the motion reads, your motion reads, Mr. Lally.
I understand. But it was more of a notice that the Commonwealth doesn't seek to introduce any evidence of that. But at the same time, obviously, if the truthful and honest answer to a question that's posed of a witness references that, then I think it comes in.
All right. So I think we're all on the same page. Neither of you intends to introduce this in your cases, but if you open the door, or if it's a natural response from a witness, it comes in. Okay. All right. So, Jim, is 289 defendant's motion eliminated to exclude the plasma, serum plasma, the blood alcohol testing, or are my numbers all off?
That's 289.
Yeah. All right. And the Commonwealth has a paragraph or two responding in one of your other motions. So I will hear the defendant on the motion regarding the testing of the blood from the hospital for the alcohol levels.
Thank you, Your Honor. I'll be addressing this with the court's permission. This is number, just so we keep it clear in my head, I had named this number 17, dealing with the retrograde extrapolation.
Okay, we don't have it as 17 anywhere.
I thought that was the list that the helpful list that the Commonwealth.
Oh, okay. So our number is 289.
Right. Okay. So.
And the Commonwealth's one paragraph response is 17, but you filed the motion. So why don't we hear from you as the moving party?
Thank you. So the Commonwealth wishes to have Ms. Reed's retrograde extrapolation records admitted over naturally a hearsay objection because the Commonwealth, their position is that they are medical records. The Commonwealth misapprehends the definition, the base definition of what a medical record is. A medical record, as the court well knows, holds a very special place in the evidence code, and that's because it's not compiled in anticipation of litigation. And for that reason and that reason only, they're deemed non-testimonial and not subject to Crawford and the defendant's right to confront and cross-examine witnesses or the experts behind the reports. Medical records are different than what we have here. The extrapolation records we have here are not medical records that were generated for treatment or Ms. Reed's medical history. They're the opposite. Those records were generated specifically in anticipation of litigation and in association with this criminal investigation. Thus, they are rank hearsay. The Commonwealth claims that the records are not produced in anticipation of litigation, stating basically that during her hospitalization, law enforcement was at the, quote, beginning stages of their investigation. But what the Commonwealth fails to mention or address is that at approximately 6:30 a.m. on a dash cam video, an Officer Good, as a matter of fact, a Canton police officer, states to Detective Blank that he is going to, quote unquote, section her, which the court knows what that phrase means. He's going to place a hold on her medically. Thus, the clear intent of law enforcement hours before the blood draw was actually taken was to keep her under law enforcement's thumb as she was an immediate suspect. But there's a bigger issue, Your Honor, and that is that the parties lack the essential, both, and by the way, this goes to the Commonwealth as well, the Commonwealth, but more importantly, the defense, we all lack the essential information on how the blood was actually drawn and tested. Those standardized protocols that we all get used to in the average OUI case, drunk driving case, they don't exist here. The standardized protocols for reliable testing, they're tried and true, and every one of those protocols is missing or are missing, and that leaves the defense having to sort of guess at the validity of the underlying test, and the validity of the underlying test is the foundation on which the extrapolation is made, which is the only thing the Commonwealth really cares about. They don't care about the underlying test, they care about extrapolating backward several hours. But this sort of goes along the theme of garbage in, garbage out. If the underlying test was not valid, or it can't be proven to be valid, then of course the extrapolation is also invalid. The question remaining is, was the testing done by gas chromatography? Was it enzymatic testing? We don't know, and we'll never find out. We don't have reports to suggest that, or exactly what the validity of those tests were. So the initial result is suspect, and by extension, the extrapolation is also suspect. It bears pointing out, Your Honor, and this is the only sort of granular detail I want to get into, the extrapolation, according to the Commonwealth's expert, is somewhere between 0.13 and 0.29 blood alcohol concentration. That is a swing of more than 123%. In other words, the swing of the extrapolation is larger than any one of the numbers themselves, which means it simply cannot be reliable. It illustrates the invalidity of the underlying serum plasma test, and for those reasons, the defense objects to the admission of both the blood test, the underlying test, as well as the concomitant extrapolation.
Okay, thank you. Come on.
Your Honor, so what the Commonwealth would submit is this may have been a valid basis for a motion to suppress, but it was a motion to suppress that was never filed, and one that the defendant specifically waived. Mr. Unity waived all motions to suppress. As it pertains to Mr. Roberts from the Office of Alcohol Testing's testimony regarding the serum conversion and the retrograde extrapolation, the reason for the range is because it's math, and essentially taking into account a number of different variables. That is why the range is as it is. As it pertains to the the specific item that would be introduced into evidence, meaning the defendant's medical records, that's what the Commonwealth is referring to as the records coming in. Mr. Roberts would come in and testify as to his own analysis, his mathematical calculations, and the results based on his training and experience, which the defendant has had for over 2 years, as Mr. Roberts testified at the grand jury to that exact set of scenarios. As it pertains to the testing itself, the Commonwealth, as indicated on its proposed final pretrial memorandum, has summoned in not only the doctor who ordered the testing, the registered nurse, the nurse practitioner, who would both have been involved in the taking of the sample from the defendant pursuant to her medical treatment and medical diagnoses, as well as the director of the lab at Good Samaritan Medical Center, who would testify as to what kind of testing is done and the nature of that testing and everything else. As it pertains to those witnesses, if the defendant wishes to conduct some sort of voir dire prior to the testimony in front of the jury, I certainly have no objection to that. But any sort of voir dire of Mr. Roberts or exclusion of his testimony would be inappropriate based on the fact that the defendant has had more than ample notice as to what the parameters of that testimony would be. So as far as what would be coming in as an exhibit, it would be the medical records with that amount in it, and then would be testimony from essentially anyone and everyone involved in the ordering, taking, and analyzing of that particular sample, which then provides the basis for Mr. Roberts' testimony.
Okay. So I have like one small paragraph from the Commonwealth on this. I want a memo on this.
Sure.
All right. So I'll take this under advisement.
EM 17. There's 17.
Yeah, there's 17 we still need to address some of. All right. So that's all of the defendant's motions eliminated, correct, Ms. Giannetti?
Just a moment.
Mr. Jackson, it's all of them, isn't it?
We filed a motion for attorney-conducted panel voir dire.
Yeah, that's a joint motion, and that's what I already said we're going to talk about in panel this afternoon.
Just being complete in answer to the court's question. That was one that was not addressed, but that's fine.
All right. Oh, the request just to have panel, your motion was a little bit confusing.
Right.
So you want panel voir dire?
Panel voir dire, correct.
I'm not going to do panel voir dire in this case. So we'll talk about the particulars of it later this afternoon. All right. So on the Commonwealth's list of motions, you said that there are some that you may agree with. What besides the view? Are there any of these numbers?
Yes, Your Honor. The defense does not object to the Commonwealth's motions in limine numbers 1 through 6. Number 8.
1 through 6?
Yes, number 8. Number 9. Number 11, we obviously joined in that request.
Yes.
Let's see. Number 14, we do not object to. Number 15, we have no objection in principle, but we do reserve the right to object to just individual exhibits as they come.
Yep.
Number 18, we have no objection. Number 19, we have no objection. Number 23, no objection. Number 26, no objection. I believe
that's the one we addressed, yeah.
And number 32, we have no objection.
All right, thank you. All right, Mr. Lally, I will hear you on our paper 297, your number 7.
So, Your Honor, this is the Commonwealth's motion to preclude reference in the redacted manner of death contained on the victim's death certificate. This is a routine motion the Commonwealth files in really respect to any case. Manner of death.
That's not persuasive, so go ahead.
No. I'm just, manner of death as elucidated in the motion is not something that is typically something that is permissible to be testified to from anybody to the jury, because that's sort of the question of liability ultimately that is left to their discretion as far as how they find the facts. But cause of death obviously is something that is a medical determination. Manner of death, as the court is well aware, is there are essentially 3 or 4 different selections, and they fall into different categories. They don't necessarily mean in the medical context what they might mean in the legal context. So for that just sort of simple differentiation of meaning between the two, manner of death is not something that the Commonwealth feels is appropriate for the court, for any witness to be testifying to as far as the jury is concerned, as that's a question for them ultimately to determine. And for those reasons, the Commonwealth would ask that this motion be allowed.
All right, who's responding to this?
Thank you, Your Honor. The medical examiner who completed the death certificate in this case concluded that the manner of death was undetermined. The Commonwealth now seeks to have that portion of the death certificate redacted because it is quite clearly exculpatory. All of the cases cited by the Commonwealth deal with the issue of whether it was error for the Commonwealth to admit a death certificate listing the manner of death as a homicide, because it violates a defendant's right to due process and a fair trial under the 5th, 16th, and 14th Amendments to the United States Constitutions. None of the cases cited by the Commonwealth stand for the proposition that a medical examiner's determination that the manner of death is undetermined should be redacted. In fact, the Commonwealth cites Commonwealth versus Ellis at 373 Mass 1, it's a 1977 case, for the proposition that excluding the word undetermined is the better and safer course. But that's a misstatement of the law, and I would urge the court to read the Supreme Judicial Court's opinion in that case. What it actually says is this, quote, "Nothing contained in the record of a death which has reference to the question of liability for causing death shall be admissible in evidence. The better and safer course is to exclude from a death certificate the words homicide, suicide, or accident in a criminal trial." Notably missing from that list of words that the Supreme Judicial Court warned about is the word undetermined. That is what the Commonwealth seeks to have redacted here. The Commonwealth bears the burden of proof in this case. They have to prove beyond a reasonable doubt that a homicide occurred. and their own medical examiner has opined that she was unable to make that determination. That finding is relevant, it's exculpatory, and there's no authority that supports its redaction. Thank you.
All right, Mr. Lally, the medical examiner will be on your witness list, right? I haven't seen either of your witness list.
Yes, sir.
Okay, so I'll take this under advisement. All right, Mr. Lally, you're number 10, our number 300.
Yes, Your Honor. This motion, the Commonwealth is simply seeking to obtain core information or records of potential jurors. I'm not looking for information pertaining to jurors that, as they come in, or some voluminous amounts of every possible potential juror, but only seated jurors. And essentially, what the Commonwealth is requesting is to simply have some sort of verification that the answers that are provided by the jurors are true and accurate. This is something that is permitted by the case law, it's permitted by the statute, and it's obviously something that the Commonwealth would share with the defense as required to. But the timing of it, of what I'm asking for, and the limited scope that I'm asking for in relation to just seated jurors, once we have a full sort of set of jurors, whether that be 12, 16, whatever the court chooses as far as the number, I'm assuming approximately 16 or so. But once those are seated, the Commonwealth's just asking for some time to run those queries and provide those to counsel, and then make any further objections for cause prior to the jury being sworn.
Okay, so I know you're not in agreement. Are you opposing this?
Yes, Your Honor. Your Honor, we object for several reasons. First, the jurors are given a questionnaire which specifically asks this question. They self-report. We rely on self-reporting from jurors with regard to all questions. The Commonwealth has cherry-picked this one question to verify whether or not they're telling the truth without dealing with any of the other questions that the jurors are asked. This proceeding right now, like many of these proceedings, is being broadcast widely, publicly. There are potential jurors out now listening to this, I'm sure, waiting for an answer from the court as to whether or not they will undergo that further invasion of privacy. And they are also, I would submit, aware that in this unusual case, the Commonwealth, through their special prosecutor, has sought to charge picketers, protesters in a very unusual manner. We would claim a harassing manner. And our position is that this is just another method of harassment. We believe it's unfair. We ask the court to deny this motion.
Do you have any case law to support your argument, Mr. Yannetti?
You're right. The case law is simply the constitutional rights to privacy that the jurors have. I mean, it's an issue of fairness, Judge. So that's what we're relying on.
All right. So the motion is allowed, Mr. Clerk, number 300.
Thank you.
All right. Mr. Lally, you're coming into number 12 with me quite skeptical. Number 12, leading questions for 13 and 16-year-olds.
And again, Your Honor, let me just first start by saying I don't think that this is something that's going to be absolutely necessary, given what I know of the two child witnesses in this case. Only filing under abundance of caution, more so should the need arise based on less so the age of the child, but the age of the child taken in conjunction or in the context of sort of the atmosphere of testifying specifically in this case, in this courtroom, with different things going on as far as the amount of people and things of that nature. So again, I don't foresee this being an issue, but just an issue that I wanted to flag for the court should it become an issue and seek sort of the court's ruling or permission in regard to it prior to any sort of incident arising.
Okay, given that caveat, is there any objection?
No objection at this point, Your Honor. We can address it as it arises.
Okay. Mr. Lally, keep in mind the jurors would much rather hear from the witnesses than from the Commonwealth.
Of course.
All right. Mr. Clerk, on that, we're just going to withhold ruling. Withhold ruling until a later time. Commonwealth, you'll raise this again if need be.
Yes, sir.
All right. All right. So on your next motion, your number 13, I had it. I don't have it in order. Just give me a minute. So I'm curious, do you happen to have, oh, we don't have the screen up. Do you happen, I'd like to see exactly what it is that you intend to introduce. So this is your motion eliminated to admit evidence that the defendant was in custody for a period of time after her arrest. Jim, is it possible for you to print that for me?
13.
Yes, please. Thank you. Okay. All right. I'll hear you on this, Mr. Lally, and remind me the date that this body cam footage was taken.
So, Your Honor, this is in reference to the defendant's arrest post-indictment. statement by the grand jury in this case. So it's June 9th, 2022.
So that's why I have not seen the video itself.
Correct. And that's certainly something that the Commonwealth can provide for the court. But essentially, when she's arrested and during the booking process at the Milton State Police Barracks, the troopers who conducted that arrest were wearing a body-worn camera pursuant to their BWC policy with the state police. Counsel has a copy of the policy, counsel has a copy of the video. And essentially, there are a number of different statements which provide sort of third, fourth, fifth, sixth, I'm not sure what number we're up to at this point, of sort of varying accounts that the defendant has provided to
Can you give me an idea now? Do you know the substance?
So the substance of these particular statements is the defendant, Ms. Reed, continuously is told by Sergeant Buchanan to essentially stop talking. He's advised her of Miranda and advised her to stop making statements, and repeatedly states that to her during the course of her making statements. But the sum and substance of it is she says something to the effect of, are you in on the joke? And then makes some sort of reference to having witnessed Brian Albert and Colin Albert essentially smash John O'Keefe's head into the taillight, indicating that that's how her taillight was broken. Doesn't make any sort of further statements about why she would then leave the scene after that occurred or anything like that. But these are, again, different accounts that have been made in direct variance to prior statements that she made January 29th to the troopers, to paramedics, to treating medical professionals, to Ms. Roberts, to Ms. McCabe, to the niece of Mr. O'Keefe, to a whole other sort of slew and variety of people with a different sort of variation on what transpired each time. So it's sort of inextricably intertwined with the fact that she's in custody.
How so? Is she in handcuffs? Is she in a
She's
cell?
seated at the booking desk or the booking rail in the state police barracks. So, I mean, I don't need to make direct reference to it. It's just, again, it's something out of abundance of caution based on sort of where it is and when it is that the statements are made, that it may naturally sort of come out as far as if the court wishes. I think it's something that the court can cure by issuing a curative instruction if there's any prejudice to be suffered by the defendant. But again, it is a statement by the defendant, which is admissible, as the court is well aware. And then it is sort of in the confines or in the context of her being in custody when she makes that statement. I certainly wouldn't be trying to elicit testimony that she was in custody, but it is kind of apparent that she is.
Can you have that here for this afternoon?
Yes, I can arrange for that.
So we can see it?
Sure.
All right, what's the defendant's position here?
Object. Your Honor, we're in a situation now where the Commonwealth arrested Ms. Reed twice when they didn't have to. I made the argument to you at arraignment back in June of 2022 that after John O'Keefe was found dead on the lawn of Brian Albert's home, I immediately got a letter out to the state police saying, I represent her, I will surrender her, no need to arrest her, just call me and I'll bring her in. They ignored that and they arrested her to get her into custody. I would assert ultimately to make the arguments that Mr. Lally is making today. Then, astonishingly to me, after the grand jury issued indictments, based on basically no new evidence, they upcharged her and once again did not contact me, despite the fact that she was completely in compliance with the terms of her release and had made every court appearance. They arrested her again. And so, again, I would assert to be in the position that they are in today. With regard to the case that they cited, Your Honor, Hoffer does not stand for the proposition that they claim that it does. In fact, the issue of that defendant being taken into custody was stricken by the court. The testimony in that case that was allowed or sanctioned by the SJC was evidence that the defendant had been living with his girlfriend but had unexplained absences. He didn't get along with her son. She was afraid of him, and that he associated with a convict that made her nervous. There was nothing about him being in custody that was admitted in that case. To the extent that these statements are, or the court deems these statements to be relevant and admissible, there are other ways to do it. I do urge the court to watch the video.
Yeah, I think we'll put it on the screen because I want to see how the jury would look at it.
Okay, that's fine. But I will suggest, Your Honor, that there are other ways to accomplish that, either to have testimony about what it was, or failing that, to have the audio of my client making whatever statements they seek to introduce without the video. An image of my client, in handcuffs at a police station is what this court generally tries to avoid, given the fact that as she sits here and as this trial is ongoing, she's presumed to be innocent. We wouldn't bring her up here in an orange jumpsuit and then ask the jury to make decisions about her, nor should we display her, after a perp walk at the police station in handcuffs, making these statements.
All right, so I need the Commonwealth to, do you have the media person available, Ms. Gilman or Ms. Crawford or whomever?
Yes.
All right,
We're seeking to make arrangements for that.
All right, we'll put it on the screen just so I can see how the jury would feel. All right, thank you. So we'll look at that this afternoon. All right, so I'll hear you on the celebrate motion, your motion number 16, Mr. Lally.
Thank you. Thank you, Your Honor. So in this motion, what the Commonwealth is requesting is for permission for the Celebrite expert, Mr. Whiffen, to conduct a demonstration in the courtroom during the course of his testimony in regard to the examination that he did in regard to Ms. McCabe's extraction report, and specifically the alleged search, which the defendant reports occurred at 2:27 in the morning, and the Commonwealth maintains occurred at 6:23 and 6:24.
I'm going to stop you because one question is, how long will this take? If we allow it, how long will the demonstration take?
So really what I'm seeking to do ideally would be for sort of a live demonstration, which I had Mr. Whiffen do and record, and provided a copy of that to counsel as well. So that recording that I provided has no audio to it, but there was also a PowerPoint presentation that Mr. Whiffen prepared in relation to the same issue that he produced, and then I provided that to counsel as well, which essentially goes through what he did. And it also—
You're not looking to do a PowerPoint presentation, are you?
No, the PowerPoint presentation would not be something I'd be looking to admit. The reason I did the video is in the event that technology is not our friend on that particular day and the live demonstration doesn't work, I would then be seeking to introduce the video and have him talk about it while it's playing. It mirrors essentially or exactly what Mr. Whiffen had included in his report, which was done back in almost a year ago at this point and has been provided to counsel, and is essentially the same thing as what's contained in his report, but just as far as a visual aid and demonstration for the jury. I just think it's a bit, when particularly talking about sort of the technical aspects of his particular analysis, the Commonwealth would submit that it would be helpful and assistive to the jury in order for them to have that sort of visual demonstration to go along with obviously the oral testimony of the witness as well.
All right. Who's arguing this for the defendant?
Thank you, Your Honor. We received from the Commonwealth the video that Mr. Lally just described about 48 hours ago. So we have not had an opportunity to confer with our expert about that particular issue.
Okay.
However, just from sort of a cursory review, it does appear that its admission is improper. As the Commonwealth acknowledges in its motion, in order for the court to allow a courtroom experiment or reenactment, there are very strict rules concerning that experiment. It has to replicate with exactitude the actual event so that it is fair and informative for the jury. Otherwise, it's prejudicial and would serve only to confuse the jurors. Here, just based on a cursory review, it does not appear that Mr. Whiffen's in-court experiment replicates all of the factors that we know were in existence at the time in question.
Does it replicate the factors that he says he considered?
So I'll need to have a little additional time if the court doesn't mind to confer with my expert.
Yeah, so I will give you time to confer with your expert and file a written response. But that's one of the factors that I'm asking you to look into.
Understood. And then just if the court does intend after a written briefing to consider admitting that evidence, we would ask to be able to take their expert on voir dire as to that particular issue.
Okay.
Thank you.
All right. How much time, Ms. Little, do you think you'd need to confer with your expert and put something in writing?
I believe about a week should be sufficient, Your Honor.
Okay.
Thank you.
And I'm sorry, I neglected to answer the court's question as far as timing. The video demonstration, which is essentially what I'd be asking him to do, is about 19, 20 minutes.
All right. So, Mr. Clerk, that's under advisement. So what remains on Commonwealth's motion 17? The statement, so I know this also went to the blood draw, but there were statements. That's what separates this from the defense motion to exclude the testing. So I'll hear you on that.
Sure.
Is the defense objecting to that portion of the Commonwealth's motion?
Thank you for that opportunity. Not particularly, no. It's the blood draw and the
Yeah, so the motion had both. So that's why, all right. So I guess we don't need to hear. So the part of your motion that concerns the statements made by the defendant, the defense is not objecting to.
No, very obviously, they're admissions. And everybody knows what the rules are dealing with admissions. So I'm not concerned about that.
Okay. All right. So Jim, on 307, it's a split. The Commonwealth is permitted to introduce statements made for purposes of medical treatment. And the certified medical records. But there's an objection as to what we've heard regarding the alcohol testing, the blood testing for alcohol. Okay. All right. Your number 20, Mr. Lally. Our number
20, Your Honor, I believe, refers back to the same argument that the Commonwealth had made in opposition to the defendant's motion to exclude anything about the nature of the relationship,
okay.
Things of that.
That's why I don't have it right here. Okay. 21, the out-of-court statements regarding the victim's state of mind.
So 21 sort of pertains to that same issue as 20. So essentially, it's the same argument. You're on the same facts underlying it as far as statements that the victim, Mr. O'Keefe, made to.
But were you making statements regarding like bins in those cases, Commonwealth versus bins, the state of mind of the defendant I mean, state of mind of the victim, the defendant knowing it, the defendant being able to act as a result specifically.
So on that sort of specific application of it, and that's why we filed two separate motions in relation to it. But as it applies to that, the Commonwealth would submit it as clearly the its burden on the case law as it applies to that because of the nature of some of those communications. So it's not just communications that are observed by other parties as far as what the victim, Mr. O'Keefe, indicated to Ms. Reed, or these aren't situations like in some of the case law where it's an indication to a third party and the defendant wasn't present, and then there's sort of an inference that can be made that, well, if they're saying it to this friend of theirs, then they must have communicated that to the person with whom they're in the relationship with. In this instance, Your Honor, we have direct communication between Mr. O'Keefe and Ms. Reed via text communications from each of their phones, indicating that communication about ending the relationship was made just prior to the date of his death in this particular case. So it not only enhances what I would submit is corroborates the testimony from other sources or from other family members and other witnesses. So for those reasons, the Commonwealth would ask that this motion be allowed.
All right.
Your Honor, on this motion, our position is that we'd like more specificity about which statements the Commonwealth is indicating they seek to admit. I imagine
It's the same thing I said to you, Mr. Lally, on the other one that was in connection with this. So the Commonwealth will do that?
Yes, Your Honor.
And I think then at that point we can evaluate it, Your Honor. Certainly some of these statements are going to come in, but we'd like the opportunity to be able to object if they...
No, I agree. So it has to be clearer. So, as far as your notice to the defense, you can even point to grand jury minutes or whatever, but I need to know the statements you intend to introduce.
Understood, Your Honor. And what I can do and what I aim to do, just sort of an ancillary thing, is I'd like to, if the court is amenable and counsel is amenable, to pre-mark as many exhibits as possible, just to make the situation easier for both sides, as far as referencing documents, photographs, videos, things of that nature. So when it comes to, I'm not seeking to introduce, when it comes to any sort of the cell phone abstractions, I'm certainly not opposed to admitting the entire abstraction dump essentially from anybody's individual phone. But what I'd like to do as far as exhibits are concerned is to print out or create sort of extraction reports from those cell phones as far as different communications between person A, person B, just to make it more simple for the jury to digest it and more simple for, I think, everyone involved to understand sort of the exact communications that we intend to talk about. So in that vein as well, what I can do is provide a supplemental memorandum in regard to 20 and 21, referencing sort of those specific conversations.
Okay, that'd be great. And if you can work together, and this will be part of the housekeeping we talk about this afternoon, work together to pre-mark exhibits, that would be great. All right, so 22.
So again, with respect to 22, and I think the same can probably be said for 23 and 24 and 25, is that essentially, as I've stated earlier, the Commonwealth is somewhat operating in the dark, and that I don't have any discovery, I don't have a witness list, I don't have any investigator reports or notes or notice of an expert or notice of any sort of expert reports, curriculum vitae, really anything. So out of an abundance of caution, the Commonwealth filed motion to eliminate number 22, which is in reference to any alleged bad character or any prior misconduct of the victim or any witness that the defendant alleges to seek to elicit through whatever witnesses they may or may not have. But essentially what I would state in regard to this specific issue is that, as the court is well aware, it has to be something that is, first of all, relevant to anything, and it also has to be relevant to a reputation, not just an anecdotal something that's brought up from one witness, again, who I don't even know who those witnesses would be at this time. So I don't know that the court can rule on it without any sort of notice as to whether or not the defendant intends to seek to introduce such evidence or has any such evidence or who those witnesses would be or what their level of knowledge would be. But it's something that I at least wanted to flag for the court in regard to if it comes up as we go along.
Who's responding?
That would be me, Your Honor. Thank you. This will be very brief. The Commonwealth, at least in their moving papers, Mr. Lally, I think, has gently stepped back from the moving papers a little bit. The moving papers suggest that they seek to preclude the defense from presenting any evidence to the jury that one or more of their witnesses lied or gave false information in this case in any particular. They call this, they do this under the rubric of bad character, but that misunderstands or misapprehends what character evidence actually is. Character evidence or bad character evidence refers to using past behaviors or past traits of a person to prove a propensity to act in a certain way in the future. Conversely, proving that someone lied or gave false or misleading information in regards to a specific matter that's relevant and material to the case at hand, that's called impeachment. And that's allowed in every single courtroom.
So impeachment's certainly allowed, but do you intend to put on witnesses regarding challenging character evidence?
No, we're not intending to. That's exactly what I was going to summarize by saying that the bad character focuses on general character traits, whereas impeachment deals with people who lied or were untruthful. We intend to be the latter.
Hold on, Mr. Lally, you're not objecting to impeachment, prior inconsistent statements, things like that.
No, of course
so
not.
Counsel, you mentioned that there is a distinction between character evidence and straight impeachment. Character evidence is not permissible because you're not going to introduce it, you said, right?
We're not seeking to introduce it at this point. We wouldn't. I mean, obviously, the trial has to play out. It's going to be several weeks. And by the way, Mr. Lally has mentioned over and over and over about how he has no reports and no statements, et cetera. He's got more than 7,000 reports and statements, both from his own investigation and from the federal investigation, that in no small part encapsulates a lot of what we intend to impeach with. However, as I stand here today, I can report to the court that we don't intend at this juncture to put on bad character evidence. We don't know what that might look like. But if we did, obviously, I know the rules. I would give the Commonwealth due notice. And and the court notice before we went that direction.
All right, so 312, Mr. Clerk, is allowed. If you need to readdress that, defense counsel, you need to file a motion. Okay, so 312, Jim, is allowed. Same thing, do you intend to put on character evidence? It's a difficult standard or potentially problematic, but do you intend to do it?
Your Honor, we at this juncture do not have intent to put on character evidence, but we will give the court notice as well as Mr. Lally notice if we do change our mind.
All right, so 313, Jim, is allowed and defendants can renew it.
I'm sorry, what's the second part?
Defendants can renew it
Yeah.
by written motion. How about 24? Is there an objection to that?
I believe that was 24, yeah.
No, it's 23.
Oh,
Did-
I apologize. 23, we had said we had no objection.
Okay, I didn't
And
have that.
24 is the opinion or character.
Okay, so 24's, all right.
I'm sorry.
24 is allowed, Jim? 23 and 24 are allowed. All right, there's an objection to 25, Ms. Little? Just
Yes,
yes or
Your
no?
Honor, Mr.
All right,
Jackson is-
so I'm going to hear from Mr. Lally on the motion. I just wanted to know if there was an objection.
Your Honor, I could probably, I don't mean to step on Mr. Lally's toes. If he wants to talk, he can talk. We don't anticipate asking any of our experts to read from treatise. If that's what his concern is, and that's how I read the motion, we don't anticipate doing that. That's my short circuit.
So no treatise, no studies?
They will refer to studies, not to read from studies on the witness stand at this point, at this juncture. Certainly, their studies are the foundation of every expert's testimony.
Okay, but what he's saying is he has no discovery of even who your experts are. So how's he going to read all these
I
articles?
understand. I
So,
understand that. As the court knows, and we anticipate, and I think Mr. Giannetti is going to address this with the court soon enough, he will be getting our expert reports. We now have finally their final notice of what their discovery is.
certificate of compliance.
And we are anticipating by the beginning of trial, by Tuesday, to have something in response to that. But no, we're not going to elicit an expert to sit there and read from a study or read from a treatise, if that's what their concern is.
Anything you wanted to add to this? It looks a little broader than that to me.
It is a little bit broader than that, as far as it also refers to anecdotal experiences or things of that nature, which obviously wouldn't be contained within a study or wouldn't be contained within certain materials. So I'm sure counsel is well aware, and I'm not certainly saying that they're not, as far as what an expert can testify to and what an expert cannot testify to. But essentially, what an expert can testify to is facts that they personally observe based on testing or things that they do themselves. Facts in regard to things that are in evidence or things that the counsel reasonably expects will be put into evidence. But the studies themselves, any sort of anecdotal experiences that they may have had or any sort of scientific literature is not something that is permissible to be admitted as an exhibit. So if that is something that they seek to talk about, the Commonwealth would submit that that's improper. You know, what they did in this particular case, sort of what their baseline of experience is, what their baseline as far as their educational background in order to form some sort of opinion based on the facts as the jury finds them is certainly fine. But making any reference to, because it happened in this study, it must be true in this case is something that's simply not permitted.
Okay.
If I may, just briefly.
Sure.
Mr. Lally uses the phrase anecdotal experience. That's the first time I've ever heard that in this context. I don't know what he means by that. But if what he means by that is bringing into court something that the expert has done or experienced or has experience with, and then relating that back to his opinion or her conclusion, isn't that what he's suggesting Mr. Whiffen do with his in-court experiment? That sounds like an anecdotal experience. But that's just me. I think we have to take this on a case-by-case basis and figure out what the experts are going to say. I don't know what anecdotal experience means. So I can't really defend against that because I put hundreds, if not thousands of experts on the stand. I don't know that I've ever asked, can you tell the jury what your anecdotal experience is with fill in the blank? So I'm not sure what and I'm not being glib, I just don't know what that means. So I don't know that the court can adequately rule on it. I think this may be something that we wait until.
So let's get the list of the experts. Take a look at the Commonwealth's the defendant's expert discovery to you, and you can raise it again.
Thank you, Your Honor.
Thank you, Your Honor.
So Jim, let's say no action taken. All right, 27. I'll hear you, Mr. Lally.
Yes. So, Your Honor, this motion eliminates in reference to prohibiting reference to any federal investigations conducted by the U.S. Attorney's Office or the Federal Bureau of Investigations. So to this point, the U.S. Attorney's Office has publicly confirmed that at no time has the U.S. Attorney's Office named any person or entity as a target. So any sort of reference to, and essentially what they've stated throughout the course of, and I know the court has had a chance to review those materials, but what they state is essentially their investigation into some unnamed criminal activity or some unnamed crime or there's nothing specific to any specific person or entity that is contained within those materials. So what the Commonwealth is submitting is that any reference to the fact that those things occurred is therefore unfair, essentially biases against one side or the other based on that, and it really has no relevancy. As far as making reference to, if counsel at some point either side wants to make reference to testimony or statements, reports, things of that nature that were provided in the course of that discovery pursuant to the TUI, obviously that's perfectly permissible, but it also can be done without making reference to where that item came from. As far as you testified previously in relation to some investigation on such and such a date. You spoke to a law enforcement agent on such and such a date, and you said this. So if it's needed for those kinds of reasons, as far as impeachment and whatever, that's obviously perfectly permissible. But any reference to that in front of the jury, Your Honor, is something that the Commonwealth would submit is simply impermissible and irrelevant to the facts as they pertain to this case. So for those reasons, the Commonwealth would ask that this motion be allowed.
Is there an objection to this?
There is.
All right, guys. Well, I am going to, I don't know if anyone is still here, but I'm going off and I'm going to watch my Rat House Media friends, my chat rats. I will see you then. I will see you there. And I will see you guys. Anybody who's here, I will see you next time for some more pretrial motions so we can get into the actual first trial. All right. Have a good night, guys. Bye.